Good morning. It's good to see everyone today. And today is Tuesday, May 5th, 2026. My name is Greg Gilbert, and I currently have the honor of serving as chair of the Tennessee State Board of Accountancy. This is a regularly scheduled meeting of the Tennessee State Board of Accountancy. It is 8:30 a.m., and I would like to call this meeting to order. Notice of this meeting, including date, time, and location, has been posted on our website. The agenda for this meeting was posted to our website on April 27th, 2026. As the first order of business, I would like to conduct a roll call to ensure that we have a quorum. All votes today will be conducted via roll call. So Karen, would you please call the roll?
Sam Bennett,
Here.
Brad Buchanan,
Present.
Michael Bryant,
Present.
Brad Floyd,
Present.
Greg Gilbert,
Present.
John Griesbeck,
Present.
Amelia Hart,
Present.
Daniel Moore,
Here.
Rob Vance.
Present.
It appears that we have a quorum. I think Andy Bonner will not be here today, and David Crenshaw may join us remotely. We're just not sure at this point. But individuals who wish to make a public comment on an item listed on the agenda during the scheduled public comment period will need to sign in on the provided sign-in sheet, which I think is at the back of the room. Or the individual may place his or her name in the chat box online. It is requested that comments be limited to 3 minutes out of respect for other speakers. And at this point, I would like to welcome visitors. I see we have a few today, and welcome. Also, I see in the back Karen Fitzgerald, Karen's CEO, President and CEO of Tennessee Society of CPAs, and she will be presenting to us later this morning. I would like to note that this is the last meeting at the end of the 3 consecutive terms of service for Andy Bonner. And Andy actually is interviewing today for the vice chair of NASBA. I think there are 6 individuals who made it to this level, so that the final interviews are today in Dallas. So Andy will not be joining us. But today is the last official meeting for Andy's term. He was appointed by Governor Bill Haslam with subsequent reappointments made by Governor Bill Lee. There is not currently a pending appointment to fill Mr. Bonner's seat. So in all likelihood, we will see Andy at our next meeting because he will continue to serve until there's been an appointment for that position. We do have a plaque to give to Andy in recognition of his years of service to the board and the state of Tennessee. And we hope to be able to present it to him at the August board meeting. I will mention all of you know Andy, and typically he and I ride to Nashville together for these meetings, and the car was really quiet on this trip because Andy was not with me. But we, of course, wish Andy the best today, and I know he would certainly appreciate your prayers and thoughts regarding this interview process with NASBA. A lot has transpired since our last board meeting, and we will update you on those items. One particular note that I would mention to you is Jen and Reed Witcher and I attended a self-sufficiency hearing before the Government Ops Committee. I think that was in February, late February. Is that right, Jen? Anyway, but since our last board meeting and before this one, and we had the opportunity to discuss our budget and our finances, but there were multiple boards that were there doing the same type presentation. And but Jen will give you an update on that also. I also would remind board members, please turn your microphones on when speaking and off when finished. Only 4 of the mics are operational at any given time. So out of consideration of others, just be cognizant of that. Our next order of business this morning is to review and adopt a meeting agenda. And members, if you would please review the agenda provided in your meeting materials. If there are no proposed changes, we do need a motion and a second, and then a vote to adopt the agenda. So I would entertain a motion to approve the agenda.
So moved.
So moved. Do I have a second? Second. Those in fact, I was told all votes today need to be roll call. Is that correct? Okay, so Karen, would you do a roll call, please?
Sam Bennett,
Aye.
Brad Buchanan,
Aye.
Michael Bryant,
Aye.
Brad Floyd,
Aye.
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Amelia Hart,
Aye.
Daniel Moore,
Aye.
Rob Vance.
Aye.
Thank you. Our next order of business is to approve the minutes from our February 3rd meeting. And are there questions? Motion to approve?
Motion to approve?
Motion to approve. Do we have a second?
Second.
Second. All in favor of Karen, roll call, please.
Sam Bennett,
Aye.
Brad Buchanan,
Aye.
Michael Bryant, Brad Floyd,
Aye.
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Amelia Hart,
Aye.
Daniel Moore,
Aye.
Rob Vance.
Aye.
Thank you. At this time, I will turn the meeting over to one of our board attorneys, Lee Lott, and Lee's going to lead us through the rulemaking hearing.
Yes, sir. Thank you. First, let me introduce everyone to Ms. Michael Tolan, who's our court reporter. And Ms. Tolan is here to transcribe the portion of today's board meeting that concerns the rulemaking. She's here to transcribe the rulemaking hearing. So Ms. Tolan, if you're ready to start, then please, yes, thank you. And for Ms. Tolan's benefit, if you would please, if you do speak at any point, make sure to first say your name, because she's typing down every word she hears and needs to be able to identify who's saying which words. And also, I'll apologize in advance. I'll be reading much of this so that we make sure to follow all the required steps, all the statutory and rule steps for rulemaking. I just glanced behind me to see if we have any members of the public. Members of the public, of course, are welcome to come to this, just like the entire board meeting. And if so, we'll have a portion of today's rulemaking hearing where they can speak. So without further ado, I'll start the formal reading of this rulemaking hearing. This rulemaking hearing is called to order. My name is Lee Lott. I serve as an Associate General Counsel for the Tennessee Department of Commerce and Insurance, Division of Regulatory Boards, and I represent the Tennessee State Board of Accountancy. Would the agency representatives who are present today please introduce themselves for the record?
Jen Binkley, Executive Director.
Sam Bennett. Brad Buchanan. And board member.
John Griesbeck, board member.
Greg Gilbert, board member.
Rob Vance, board member.
Brad Floyd, board member.
Amelia Hart, board member.
Daniel Moore, board member.
Thank you. Today is Tuesday, May 5th, 2026. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 4-5-204 in Conference Room 1A, Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. And it is available by electronic means via WebEx webinar. The link for today's webinar is available at the board's website, contained within the state's website, www.tn.gov. At the board's website, please follow the links for public meetings and then follow instructions for joining the webinar. The purpose of this rulemaking hearing is to solicit comments on rule amendments to the rules and regulations of the Tennessee State Board of Accountancy. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State. Notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, the end of which time they will become effective. Please listen carefully. Those members of the public wishing to speak and appearing in person should place their name on the sign-in sheet on the podium behind me to my right. Those members of the public wishing to speak and appearing via webinar should put their name in the chat box online. Oral comments will only be accepted by those who have written their name on the sign-in sheet or typed their name in the chat box. Is there anyone else that desires to offer oral comments but has not written their name on the sign-in sheet or typed their name in the chat box? Seeing that there are none, for those attending this hearing in person, I would call your attention to the podium behind me. Again, on this podium, you will find red-line copies of the rule amendments addressed in today's rulemaking hearing. For those attending on the webinar, you will find a link in the chat box to the red-line copies for today's hearing at the Secretary of State's website. Ms. Tolan, am I speaking at a proper cadence and speed? Okay. The notice for today's rulemaking hearing included the entire text of the proposed rules and were published at the Tennessee Administrative Register website on January 26, 2026. Ms. Binkley, what additional notice was given to the affected individuals or groups?
Information for the time and location of the hearing was placed on the board's website, and an e-notify was sent to all licensees signed up for the program system on February 26, 2026.
I will now summarize the proposed rules for the record. The rule amendments proposed today implement the conclusions reached in the retrospective review process required by the Uniform Administrative Procedures Act, Tennessee Code 4-5-213. The rule amendments also implement the accountancy provisions of the Less is More Act of 2025, Public Chapter number 524, Sections 31 through 38. Specifically, the rules amend procedures for the licensure of certified public accountants, known as CPAs, of course, the renewal of CPA licensure, the reinstatement of CPA licensure, the interstate practice of accounting, the experience requirements for initial licensure, and continued professional education. These amendments accomplish the following. They define the phrase license in good standing. They allow for a more expeditious time frame for the board to hear a request for license reinstatement. They clarify the persons to be listed on applications for initial licensure or renewal of licensure. They remove the requirement for the board to communicate via registered or certified mail when requiring a licensee to respond within 30 days. They clarify the circumstances upon which a licensee must notify the board of a conviction of a felony. They clarify how CPE carry forward hours can be used to satisfy CPE requirements. They limit the number of hours that a licensee may earn in a single day, which is sometimes a factor for people who try to watch videos quickly. On this point, please allow me to point out something in your materials, specifically in the Notice of Rulemaking hearing. In Board Rule 20-05.03, there is a proposed amendment adding a subsection 1F, which reads as follows, quote, no more than 12 credit hours of CPE can be earned in a single calendar day, end quote. Board staff today is recommending that this language read 24 hours, not 12 hours, as stated in your materials. So later in today's meeting, when the board votes whether to adopt all of these rule amendments, I will mention this point again so that you vote in favor of when you vote in favor of adoption, this change in the subsection will be clear for the record. Looking back to the list of amendments, they also align CPE requirements for a recently reinstated license with that of an initial license. They clarify permissible services for CPAs in inactive status. They clarify that a licensee may only convert a license to inactive status if the licensee holds a license in good standing. They extend the time period in which a licensee with an expired license may obtain required CPE. Credit to reinstate licensure, extending the time period from 6 months to 12 months. Today's amendments also include a number of formatting and citation updates. Having summarized the rules and their amendments, I will now turn to the comment portion of today's hearing. I did not receive any written comments prior to the hearing. Ms. Binkley, are there any written comments received by the board that I have not seen?
No.
Possessing no written comments, I will now solicit comments from individuals present at today's meeting, either in person or via the webinar. As the board hears comments, I reserve the right to limit such comments if they become repetitive. I would ask individuals to please limit your comments accordingly. When your name is called, please come to the podium and concisely state your comment. So I'm not seeing anyone in the board meeting room here. No one is approaching the podium. Therefore, next, I will read the names of individuals who have placed their names in the chat box at the webinar. Is anyone in that chat box?
No.
Okay. It appears that we have no one in the chat box. No one is alerting us online of the desire to speak or to make a comment about the rules amendments. Therefore, and let me double check. This now concludes the comment period for the rulemaking hearing today. Now, there are several measures to place into the record as required by Tennessee law, including Tennessee Code 4-5-222. First, I will need a motion from some member of the board to adopt the hearing rules as amended. When I say the hearing rules as amended, I mean all of the amendments listed in the notice of rulemaking hearing, as well as the single amendment that I mentioned earlier, changing the number of hours from 12 to 24 in Board Rule 20-5-.031F. So, on the question of adopting all of these hearing rules as amended, may I please have a motion to adopt?
This is Greg Gilbert, and I so move.
Thank you. Is there a second?
John Griesbeck, second.
Thank you. Is there any discussion?
Just curious as to.
Let me make sure your microphone is on.
How about that? Maybe it's that button.
So maybe just to be safe, introduce your name one more time.
Sure. Michael Bryant. So Lee, what?
Yes, ma'am, that's fine. Yes, ma'am. If that's okay with the chairman.
Yes, sir.
Oh, no. Well, Mr. Chairman, should we take a short recess? Or how would you like to handle that, Mr. Chairman? She's got to fix her software for the court reporting transcript.
So where we left off.
Yes, sir.
Second.
Okay.
Michael Bryan said, I'm just curious to make sure your microphone is on. Then Attorney Lott said, try it now. Does that sound better?
I believe it's still on. I'm just curious, was there some impetus to change this from 12 to 24 hours?
Okay, so I defer to Ms. Binkley on this, but I will say, most people get tired after 12 hours and you want to sleep or eat. Some people, though, might want to work through watching videos for a full 24 hours if they wish. And so during a 24-hour period, they're free to do that. We just don't want to have the situation where the underlying all of this is a need to address the situation where someone claims more than 24 hours, which we've seen people claim, strangely. But yeah, 24 is a lot. I don't know. I wouldn't be able to do that. I'd have to sleep a little bit. But have I fairly stated the response to that?
Yes, and I'll say when we were coming up with a proposal for this specific rule last summer, it was hard. It was difficult to arrive at an exact number that would be appropriate. 12 perhaps felt too restrictive for some individuals who are nearing the end of their renewal season, their renewal period, and they're interested in kind of cramming some CPE time near the end of their expiration date. And 24 hours was at the time the least arbitrary measure that we arrived at when we were internally coming up with that suggestion.
I guess in the mission to protect the public, are we protecting the public by letting people take 24 hours of CPE in one day and thinking they're getting adequate professional education? That seems, it does not seem like the best approach to me.
That's a good question. And I'll say too, there are not many states that I'm aware of that have a cap on the number of hours per day. This was something that when I stepped into this role, I immediately noticed as I was reviewing applications where people were submitting more than 24 hours of CPE a day, as Lee mentioned. And so when the retrospective review process came up for the rules, I knew this was something that I was interested in getting before the board to see what we could come up with in the interest of protecting the public. And again, if you have a suggestion of something that you would rather see there, I think the board can discuss. 24 was just sort of, like I said earlier, the least
I would
arbitrary.
offer up that I think the most reasonable upper limit would be somewhere around 18 hours, right in the middle of 12 and 24. I think 24 is subject to challenge as to how effective that CPE is for a professional. That's the end of my comments, Jim.
Thank you.
So, Mr. Bryant, I'm very glad to hear that. And of course, this is the discussion portion for the board's vote on adoption of these hearing rules. And before we address that specific recommended change and have the board comment on it, I will just say generally, of course, this is the discussion portion for all of the amendments that are listed in the notice of rulemaking hearing. So we can address that point, and it's a very well-made point. But I want to invite the board to make a point on any other issue. Now is a good time to do that. Now is the time to do that before the board votes for adoption. So, Mr. Chairman, if I may take this liberty, what I think I probably should do is ask the board to vote on whether to go with 18 or stick with the board staff recommendation of 24 and then of course, I guess we could also look at the 12, but maybe to simplify a yay or nay vote, let's start with the number 18 that Mr. Bryan has proposed. And so I would, we'll come back to the motion to adopt. I know that's the motion on the table, but, and I don't know if I'm doing this exactly correctly under Robert's rules, but if I may, I think I will ask for a motion to use the figure 18 in the subsection that I have identified here, 2005.031F. If I may have a motion to use the figure 18 hours in that proposal, please make the motion.
Before the motion, can I make one comment?
Absolutely.
Sam Bennett. I just wanted to ensure that all the board members are aware that 24 hours of CPE would actually only take 20 hours. So 50 minutes of CPE constitutes one CPE credit hour. So 24 credit hours could be earned in 20 hours. I can't do the math in my head to quickly, but I would imagine that 18 hours would take 14 hours or somewhere in that neighborhood.
Well, on the language then, let's start with the proposal for 18. And if this fails, then we'll stick with 24 unless someone has a different proposal. So may I please have a motion to use the figure 18 in subsection 1F? If you so wish, you can make a motion.
I make the motion that we use 18 hours for the upper CPE limit. Mike
Yes.
Bryant.
Is there a second? Hearing no second, then the motion fails. With the chairman's, with deference to the chairman, I'll go back then to the discussion portion. And I think for clarity on the record, we'll kind of start it over. Let's start over with the vote on the motion to adopt. Just so we're completely clear for the court reporter.
So this is Greg Gilbert, and I will make the motion to adopt the rules as amended.
Thank you.
John Griesbeck, second.
Okay, any discussion? And of course, we've already had some, but is there any further discussion on any of these rule amendments?
This is Brad Buchanan. I did with Michael, I agree with your impetus around the 18 versus the 24. However, I'm still not convinced that even 18 isn't too aggressive as a practical matter. As a person who's taken many hours of CPE over the course of my 20 plus years as being a CPA, the notion that someone could absorb 18 hours worth of CPE in one day, potentially even 12, is aggressive in my opinion. So I would offer, or maybe put on the table, that I would be very much in favor personally of leaving it where it is. I think 12 hours is a gracious plenty, and anyone who is potentially trying to do more than 12 hours for whatever reason, I'm not convinced personally that that individual would actually be able to absorb that much content in one day. But I'll offer, if anyone has other thoughts, I'm happy to listen. Thank you.
This is Rob Vance. I have I guess a comment. Do we have any statistics on how many people ask for more than 12 hours in a day? And I agree with Mr. Bennett that 24 hours credit hours only takes 19 hours, because if we shave almost 5 whole hours off of that, I just FYI. But do we have any statistics on that?
That is not Jen Bickley, Executive Director. That is not data that we track.
Okay.
And I will say for the board, when we think about this, we want to think about, Lee, feel free to jump in if I'm misspeaking, but we want to think about ensuring that, so there was previously no restriction, right? And now there is discussion of dropping it down to a 12-hour limit, which is a pretty, for a small handful of licensees, I would guess a small handful of licensees, that will be a pretty drastic, could be a pretty drastic change for those individuals. And we do want to make sure that we're not being overly restrictive for some individuals in limited cases that may need to get those hours in. Again, it's definitely the exception, not the norm, that we see individuals sending us applications for renewal reinstatement that have massive amounts of hours in a day, more than 24 hours in a day. It is the exception, not the norm. And we want to ensure that we're not, when we think about this, that we're not placing undue burden in some instances on licensees who may want to spend one day near the end of their renewal period knocking out a bunch of CPE. So that's, when we were proposing board rules, that's how I thought about it. It's like I said, it's not a widespread thing that we see. And we are going from no restriction to a restriction period. So it's already going to be a significant change for some licensees.
I have a question. Sam Bennett. If someone is doing a self-paced CPE course online, say it's an 8-hour course. They complete 6 or 7 of those hours one day, but they ultimately complete it on another day. All 8 hours would post on the day of completion.
That's typically what we see when we see CPE certificates come in, and I do imagine in some instances we'll have to seek clarification from licensees or some sort of attestation in practice if this is adopted, that if when we see that, you know, because we've seen certificates for conferences, multi-day conferences that have a 32 hours or something on there. So I envision instances where we will have to get clarification from licensees, but that what you stated does happen in practice.
This is Amelia Hart, and I would like to weigh in on this. Sorry. Yes. There was a statement that indicated 24 hours would be the least arbitrary measure. So that's one side of the spectrum. The other is this commitment to professional service, which would require education that helps inform and prepare persons who are in the public profession. The tension for me would exist that it would seem the completion of the hours to check a box would override that of public interest in that space of a service. So my concern would be with the 24 CPE that it would not be in the best interest of persons who purport to be certified public accountants. That's the end of my comment.
Thank you.
Yes, sir, Mr. Bryant.
Michael Bryant, I think it's a good thing that we are finally stating a limit in there. I think that's a step in the right direction. I think it's incumbent on CPAs to get their CPE and to get it in a way that's useful and meaningful to the public, which means they're going to get the information, hopefully, that is useful in their profession. So I guess I'm still of the opinion that 24 is a little liberal, and even 18, which is 15, is, I mean, to me, that's even giving a bit of a grace to the people who have, it's incumbent on them to get their CPE. It's the last day of the year. They haven't gotten it. So we're professionals and we should be that responsible. That's just my personal opinion.
Any further discussion?
Mr. Lott, will you clarify? This is Greg Gilbert. Mr. Buchanan's comments about maybe leaving it at 12. I think, and I think I'm quoting you correctly, I think we have moved, the rules actually have moved that to 24. So maybe it wasn't, is that correct?
Yes, let me clarify that.
Yeah, thank you.
So the rule, notice of rulemaking hearing, Secretary of State Form 7037, that was published at the Secretary of State's website some weeks ago, notifying the public of this hearing today, stated all of the proposed rule amendments. And the rule amendment for this particular subsection 20-05.031F stated the number of hours as 12 hours. And discussion at the board staff level revealed an idea. We thought we should propose 24 because that's a logical limit, but by no means do we have the authority to say that. It was something that we thought we would present for a vote. And so we would need to simply just clarify the vote and make sure that we're clear on the record what the board is wishing to do. And I can phrase that in such a way that that's clear. We've already had a vote on the question of 18 and that did not pass, but I could, if it's okay with you, Mr. Chairman, propose a vote that says, should we keep the notice of rulemaking hearing as it currently stands, stating 12 hours? And then if the board approves that, Then we'll move to a vote on adoption of all of the amendments. And the full totality of the amendment changes would include a 12-hour figure instead of a 24-hour figure, if that's how the board wishes to go. So does that sound reasonable, Mr. Chairman?
It does, and thank you for clarifying, Mr. Lott, and my apologies to Mr. Buchanan. Thank you.
Well, if there's no further discussion on the question of the number of hours in this subsection, if it's okay, I think I'll request a motion from some member of the board and the motion is that we keep the number of hours in the amendment to 20-05.031F at 12 hours. Do I hear a motion?
So moved.
Is there a second?
Brad Buchanan, second.
Okay, any further discussion on that issue? Okay, hearing no
This is
further.
Daniel, can I have one question?
Yes, sir.
If we do this, I guess, what's the process for educating the licensees about the change? And I guess if people weren't aware of it, they get their CPE at the last minute, they're not going to realize they're out of compliance until you tell them, hey, you got it all in 1 day or 2 days, whatever, right?
So we have several outreach opportunities where we could help communicate that out. Our newsletter, we can work with our friends at the TSCPA to help communicate those rule changes. We will certainly notify NASBA since they manage the registry for CPE providers. That's something that the CPE providers will likely want to be aware of, that we made a rule change in Tennessee that impacts their customers. We have several opportunities for outreach where we publish that information.
I guess, let's just say somebody tries to get too much in 1 day at December 31st, and then you notify them later, they're out of compliance. What then happens? Do they then have penalty hours at that point?
Okay, you're asking a good question. Of course, that we'd have to just handle it on a case-by-case basis and look at all the facts. It sounds like in that simple presentation, it would be a violation, and then it might be presented to the board as a possible action item. But you know, it's hard to answer that question in the abstract. You know, hypothetically, the board is here to draft the rules and amend the rules. And if someone violates it, then we'll just have to look at all the facts that apply at the time.
And Jen, you know better than any of us, like what percentage of people are doing this on a regular basis, like in terms of, you know, is it 1,000 licenses? Is it 500 people who are getting more than 24 hours on 1 day? I'm just worried from a practical standpoint, you're going to have a lot of non-compliance to deal with. Is that, you know, feasible?
Let me get you a better answer when we have a break for that.
This is Brad Buchanan. I do have a question following up on Daniel's question. Would there be an ability, recognizing that we are changing the rules, if we do instate a cap to make it effective beginning January 1st of 27, and with the next several months, the ability to advertise that and not catch anybody off guard in the current calendar year?
You know, the timing of this follows statutory procedures, and there is I think a 90-day wait period. Once the board votes today, these proposed rule amendments go through several more rounds of review, as I kind of explained earlier with the Attorney General and the Governor's office. And then at the conclusion of all reviews, they're submitted to the Secretary of State and they go into effect 90 days later how that timing plays out just depends on how long the reviews take. Now, we are currently at May. Yes, please.
I do think that we can put an effective date in our rules. We did this for peer review rules last year. We said in the peer review rules, there was a statement for all, I don't remember, I'm gonna misquote it, but for all peer reviews that begin after a certain date, these new requirements are in effect. So that could be an option here, I think, based on what we've done in the past.
I mean, that could be part of our vote for this number 12. We could simply add to it an effective date of January 1, 2027 for this particular subsection. I haven't thought through how that would look in the final version of the rules that's published at the Secretary of State's website. You know, you definitely want clarity. And the board, here's the thing, the board would only address this if it arises, right? And so if someone somehow misses the 12 number because of the timing of this amendment and in December of 2026, they're caught short, the board can look at that in a disciplinary case, if a disciplinary case arises. If that happens, the board can simply look at that and consider mitigating factors. And it's not like you're lacking tools to address unique circumstances. You certainly have those tools. So I defer to the board. For now, we're currently in discussion, the discussion portion of a vote on whether to stick with the 12-hour number. And I think what I probably should do is conclude the vote on that. And for clarity, I'll simply repeat what has been moved and what has been seconded is a vote to keep the number at 12 hours in the amendments to Rule 20-05.031F. With that being the motion, is there any further discussion?
Sam
Mr.
Bennett.
Lott, sorry. This is Greg Gilbert. I have a question for Jen, and Jen, I don't mean to put you on the spot, but I know we've talked about this in the past, and my feeble brain can't remember how this sorts out, but several states, particularly in the Southeast, but across the nation, have considered this same dilemma. And do you recall what some of maybe even our border states have done?
South Carolina, to my knowledge, is the only state in the Southeast that currently has a cap and rule. And if I remember correctly, I'm pretty sure it's at 12. Like I said earlier, there may be 2 or 3 or maybe 4 jurisdictions out of the 55 licensing jurisdictions that have a cap currently in their rules on a number of hours per day. So I think it is a lot of states express frustration with seeing this. We're certainly not alone in Tennessee with seeing licensees do this. But currently, I have not heard, except for South Carolina, who has had that rule in place for some time. I'm not aware of any other states in the Southeast, at least, that have that cap.
Thank you. I recall at one of our meetings, Alabama's executive director expressing concern over this because I think they've seen the same issues that we have, people claiming certainly in excess of 24 hours on a day, usually the last day of the calendar year. But thank you.
Sam Bennett. I think it's important to understand the volume and the frequency before we vote. I guess what I'm curious about is whether when we do see instances of 20, 24, 27 CPs being earned in a single day, is that an error in the date that those CPE were actually earned? Or is it someone actually taking 24 hours of CPE in a day? Because I would think that some of those could be conferences, some of those could be web-based trainings where the completion is, they don't take the test at the end of the, self-paced training until the day that the CP is processed. I would just be concerned about the administrative volume of having to chase down. If we found out that it was hundreds, I would be concerned about the administrative burden of having to go back and forth to figure out the facts and circumstances of everyone who claimed 15 hours of CP on a day, when maybe the actual, learning time was 5 hours on that day, but 15 CPs were processed on a single day. That would be my concern.
So Karen checked in with our education coordinator who leads all of our CPE audit efforts. And she shared it is rare in the CPE audit realm. It is rare that we would see someone submit, not never happening, but rare that we would see someone submit more than 24 hours for one day. And I can say, since I have been here, I sometimes review reinstatement applications where CPAs currently are required to submit 80 hours in order to reinstate their license from expired. And I have seen maybe 2 or 3 instances in a year and a half of CPAs who have submitted more than 24 hours in a day. We haven't been thinking at a level of more than 12, if that makes sense when we look at these things. But in terms of CPAs submitting more than 24, it's pretty rare.
Mr. Lott, Michael Bryant, I'm going to ask you a procedural question. I'm not sure that Mr. Buchanan's note about the effective date rose to the level of amending the original motion. But if it did, then I think we have to vote on that up or down.
It did not. It was not a motion. The current motion that has been made and seconded is whether to keep the number of hours at 12 hours. That's the question that is before the board, and we're having discussion on that right now. And if Mr. Buchanan or anyone else wants to make a further motion, they can certainly do so as we continue the discussion portion later on the set of amendments as a whole. So is there any further discussion about the motion, which is to keep the number at 12? And I hope I'm correct. That was the motion, right?
John Griesbeck, I'd just like to make a couple follow-up comments. One,
Please.
I applaud the staff for setting a limit. I think protection of public interest and what have you, I think that's the thing to do. Wish other states would do it. My problem with 12 hours is I think Mr. Bennett makes an excellent point. Someone could easily spend 6 hours on an 8-hour self-study CPE, finish the next 2 hours tomorrow and get his 8, do another 8, and he's got 16. So that voids 12 in my mind. I think it's just a little too low. Not to mention you're going from no limit to 12 is pretty drastic. I think there are some practical issues here with communication that Mr. Moore brought up and just not knowing exactly how many there are. And so I feel like that's a pretty drastic move there. And it's offset too by the fact that it's pretty easy to, not finish one, to finish it the next day, do another. You could stack them, I guess, for 3 days and all of a sudden have 24 reported in one day. So, and I guess, it's possible too that someone has a conference right at the end of the year. It's a 24 3-day conference and maybe the 24 goes in on the 31st and not over the 3 days, a reporting issue. Again, that Mr. Bennett kind of pointed out. So those are my comments.
Mr. Lott, I have a question, back for Jen then. I think the point, John, that you're and Sam are raising, I think is a fair one. However, that this is, if what you're describing were to occur, I presume that if that individual were selected for CPE audit, because this is where I think this would manifest, then the CPE coordination team could understand the facts and circumstances of the CPE if it was a conference or something to that effect, and have discretion to conclude that they were not claiming, let's say, 12 hours or more than 12 hours in a single day, but the reporting, notwithstanding what the reporting might indicate. Is that a fair assumption, or is this am I off base in that question?
I think that's a fair assumption. So let me repeat that back to you. So essentially, when we are performing CPE audits, staff can apply judgment when reviewing a CPE list, CPE certificates, make a conclusion that this is clearly a conference, it's clearly 3 days. That's something I would feel very comfortable with them doing. And I think that if it's obvious in the evidence that's been provided by the licensee, then we can make a conclusion on that without assuming that they're trying to do, 30 hours in a day or something. That
Sam Bennett, so would this only be enforced through CPE audits, even though it's very basic data that could be flagged by an information system and just rejected in terms of submitted CPE? Everyone's required to submit their CPE, correct? So you have a list of CPE earned by day, and it would be very easy to see any situations where someone is claiming more than 12 hours of CPE. I don't really understand why we would only subject that to scrutiny through an audit.
we do not currently have the infrastructure set up to do a 100% essentially audit of those lists that were submitted on the front end with renewal. The way we process renewals is not, we do not, if CPAs indicate that they have met all the requirements for renewal, they have that file uploaded. Generally, those renewals are processed without intervention by my team. So we're not reviewing 6,000 lists. It only comes up in CPE audits or applications for reinstatement, or an application that involves submission of CPE in order to move that would really be the only time, a reinstatement to move the status of a license.
May I add something to that? If there's a violation of a statute or rule, anyone can file a complaint. And we have an online portal for that purpose. And sometimes members of the staff enter the complaint because members of the staff identify some violation of a statute or rule. So it's not limited. Addressing this issue is not limited to audits. It could occur anytime a violation is identified, even if it's someone's partner at a firm who sees something that's askew. So the question you ask about enforcement is really a question about the disciplinary process. And I'll remind the board, the way the amended language reads currently in the notice of rulemaking hearing is as follows. No more than 12 credit hours of CPE can be earned in a single calendar day, period. And so if someone were to have a question about that and file a complaint like, hey, this is a problem, we need to look at this, it would go through the normal process. The complaint would be presented to the staff would send the complaint to the respondent, the licensee in this particular case, would have a chance to respond and explain, oh no, I took a class that was an 8-hour online block and only finished the last 30 minutes on the second day. So I didn't actually exceed 12 hours in a day. That could be explained through the normal process to determine whether a violation has occurred. And if the staff determines a violation has occurred, that's not the end of the story. Obviously, we present that in a legal report to the board, and you're allowed to ask questions and dig into it. Of course, you have an investigator who will be presenting his findings from his investigation, and the board can vote whether to commence formal proceedings. And so even then, it's not the end of the matter. You at the board, if it finds a violation of that rule, would simply be authorizing the commencement of formal proceedings. And then we would go from that to the hearing procedure under the Uniform Administrative Procedures Act, which is a detailed procedure required under the Constitution, notice in a hearing. We'd have discovery. We'd follow all the statutory procedures required by the General Assembly for administrative disciplinary actions. And so I think there are many avenues for this board to address unique fact scenarios. And I will remind the board, the question right now is very narrow. the way we have phrased it with a motion and a second is whether to keep the number at 12 as it is stated in the notice of rulemaking hearing. Should we keep it at 12? And if not, the staff is recommending 24, and then you can have a full vote on that. As we've said, we can just kind of phrase that as it needs to be phrased at the time. But I don't want to lose sight of where we are. We are currently standing at a motion to keep the number in subsection 1F at 12 hours. That's been moved and seconded. So is there any further discussion on that?
I just want to kind of summarize what I think we talked about and what I heard the board say. I think people agree a cap is a good thing. That's the first thing I heard. The second thing I heard was when you said in any given day, I think that addresses, Sam, the issue regarding things being, finished the last day and those hours showing up. They didn't actually happen in that single day. It's just whatever was used to complete it. Whatever the administrative function around determining that, that's for Jen's group to apply. And you said there weren't many. So that's the second thing. And then the third thing I think is it reasonable for a CPA to spend 24 hours getting CPE in a single day? And I would say no. So there's some limit that we're shooting for. We're starting with 12. That seems reasonable place to start. And then we can see if that needs to be changed in the future. Thank you, Mr. Chair. I just wanted to see if anybody saw it differently.
Thank you.
Any further discussion? Okay, so on the question of whether, the motion is to keep the number at 12 hours. And there has been a motion and a second and discussion. May I please have a roll call vote?
Sam Bennett,
No.
Brad Buchanan,
Yes.
Michael Bryant,
Yes.
Brad Floyd,
Yes.
Greg Gilbert,
No.
John Griesbeck,
No.
Amelia Hart,
Yes.
Daniel Moore,
No.
Rob Vance,
Yes.
We have 4 no votes and 5 yeses.
One second, please. I want to confirm something in the statutes. Excuse my delay. I just had to confirm something, but the motion passed.
Thank you.
So the number is being kept at 12. And so I think for the sake of clarity in the record, what I will do is, if it's okay with the chairman, restate the motion to adopt everything, since we're actually changing the way that's been phrased.
Correct.
I'm gonna restate that now and request a new motion and second, and then we can have any further discussion that the board would like to have on the question of adoption. So to make that point then, may I please have a motion to adopt the rules as amended and stated in the notice of rulemaking hearing for today?
So moved.
May I have a second?
Second, Greg Gilbert.
Any discussion? Hearing none?
Mr. Lott?
Yes, sir.
Excuse me. We just had a 5-4 vote, and I don't think, I just want to make this statement, Greg Gilbert. I don't think the board is very divided. I think we may just be, have a difference of opinion as to the number of hours of CPE, so I don't perceive that the board is polarized.
Each member can vote according to his or her own conscience. Any further discussion? All right, may I please have a roll call? This is for adoption of the rules as amended and stated in the notice of rulemaking hearing.
Sam Bennett,
Aye.
Brad Buchanan,
Yes.
Michael Bryant,
Yes.
Brad Floyd,
Yes.
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Amelia Hart,
Yes.
Daniel Moore,
Yes.
Rob Vance,
Yes.
The motion, the rules as amended are adopted. Next, I will read the regulatory flexibility addendum, which is required by the Regulatory Flexibility Act codified at Tennessee Code 4-5-401 through 404. As part of the rulemaking process for any rule being proposed that may have an impact on small businesses, the Regulatory Flexibility Act requires each agency to prepare an economic impact statement as an addendum for each rule that is deemed to affect small businesses. For today's rulemaking hearing, the Regulatory Flexibility Addendum consists of 6 items, and I will read each of them into the record as follows. Item number 1, the type or types of small business and an identification and estimate of the number of small businesses subject to the rule being proposed that would bear the cost of or directly benefit from the rule being proposed. The answer: there are approximately 1,700 licensed accounting firms in the state of Tennessee. The board's licensing records do not note the size of each firm since this is not required information pertaining to licensure. Item 2, the projected reporting, record keeping, and other administrative costs required for compliance with the rule being proposed, including the type of professional skills necessary for preparation of the report or record. Answer: none beyond what is currently required. Item 3, a statement of the probable effect on impacted small businesses and consumers. Answer: the rules ease licensure requirements, which will benefit small accounting firms seeking to hire competent professionals to deliver accounting services in Tennessee. The rules will also benefit consumers by enlarging the pool of professionals whom consumers may retain for accounting services. Item 4, a description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the rule being proposed that may exist, and to what extent the alternative means might be less burdensome to small business. Answer: these rules are the least restrictive means to achieve the purpose and objectives. Item 5, a comparison of the rule being proposed with any federal or state counterparts. Answer: roughly 20 or more states are currently amending their accountancy laws to increase opportunities for CPA licensure, and more are expected. Item 6, analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the rule being proposed? Answer, there's no ability to exempt small businesses. The Tennessee Accountancy Act requires licensure for individual CPAs and accounting firms regardless of their size. An exemption would not be in compliance with the act. Having now read these items, may I please have a motion to adopt the regulatory flexibility addendum?
John Griesbeck, so moved.
Yes, sir. Second,
Brad Buchanan, so moved.
any discussion? Hearing none, may we please vote by roll call?
Sam Bennett,
Aye.
Brad Buchanan,
Aye.
Michael Bryant,
Aye.
Brad Floyd,
Aye.
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Amelia Hart,
Aye.
Daniel Moore,
Aye.
Rob Vance,
Aye.
The motion passes. I will now read a statement known as the Impact on Local Government Statement pursuant to Tennessee Code 4-5-228. The statement is as follows. The board sees, I'm sorry, let me start again. The board foresees no impact on local governments. May I please have a motion to adopt this impact on local government statement?
Greg Gilbert, I so move.
May I have a second?
Amelia Hart, second.
Is there any discussion? Hearing none, please vote by roll call.
Sam Bennett,
Aye.
Brad Buchanan,
Aye.
Michael Bryant,
Aye.
Brad Floyd,
Aye.
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Amelia Hart,
Aye.
Daniel Moore,
Aye.
Rob Vance,
Aye.
The motion passes. Now, I will read into the record one final item. It's actually a list of certain items of information required by the Joint Government Operations Committee of the General Assembly and by Tennessee Code 4-5-226 I-1. All agencies, upon filing a rule with the Secretary of State, shall submit this information. The information falls into 9 topics, which are as follows. First, a brief summary of the rules and a description of all relevant changes in previous regulations effectuated by such rules. Answer, these rules amend procedures for the licensure of CPAs, the renewal of CPA licensure, the reinstatement of CPA licensure, the interstate practice of accounting, the experience requirements for initial licensure, and continuing professional education. Second, a citation to and brief description of any federal law or regulation or any state law or regulation mandating promulgation of such rule or establishing guidelines relevant thereto. Answer, the rule amendments proposed today implement the conclusions reached in the retrospective review process required by the Uniform Administrative Procedures Act, Tennessee Code 4-5-213. The rule amendments also implement the accounting provisions of the Less is More Act of 2025, Public Chapter Number 524, Sections 31 through 38. Third, identification of persons, organizations, corporations, or governmental entities most directly affected by each rule, and whether those persons, organizations, corporations, or governmental entities urge adoption or rejection of each rule. Answer, these rule amendments will affect CPAs licensed and or practicing in the state of Tennessee. The board anticipates the National Association of state boards of accountancy, otherwise known as NASBA, and other professional associations to be proponents of the rule amendments. The board does not foresee opposition to the amendments. Fourth, the identification of any opinions of the Attorney General and reporter or any judicial ruling that directly relates to the rule or the necessity of to promulgate the rule. Answer, there are no known opinions of the Attorney General and reporter or any judicial ruling that directly relate to these rule amendments or the necessity to promulgate the amendments. Fifth, an estimate of the probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of this rule, and assumptions and reasoning upon which the estimate is based. An agency shall not state that the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's annual budget or $500,000, whichever is less. Answer, there is no foreseeable probable increase or decrease in state and local government revenues and expenditures. Sixth, identification of the appropriate agency representative or representatives possessing substantial knowledge and understanding of the rules. Answer, Jen Binkley, Executive Director of the Tennessee State Board of Accountancy, and myself, Lee Lott, Associate General Counsel for the State Board of Accountancy. Seventh, identification of the appropriate agency representative or representatives who will explain the rule at a scheduled meeting of the committees. Answer, Reed Witcher, Assistant Commissioner for the Division of Regulatory Boards, Candace Dawkins, Legislative Director for the Department of Commerce and Insurance, and Jen Binkley, Executive Director of the Tennessee State Board of Accountancy. Eighth, the office address, email address, and telephone number of the agency representatives who will explain the rule at a scheduled meeting of the committees. Answer, for all three representatives, the office address is Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee, 37243. The email addresses and telephone numbers are as follows: reed.witcher@tn.gov, 615-879-3239, Candace.Dawkins@tn.gov, 615-253-6913, Jen.Binkley@tn.gov, 615-968-4503. Lastly, any additional information relevant to the rule being proposed for continuation that the committee requests. Answer not applicable. Having now read the information required by the Joint Government Operations Committee, may I please have a motion to adopt this information?
Motion to adopt this information. John Griesbeck.
Thank you. Is there a second?
Michael Bryant, second.
Any discussion? Hearing none, please vote by roll call.
Sam Bennett,
Aye.
Brad Buchanan. Michael Bryant,
Aye.
Brad Floyd,
Aye.
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Amelia Hart,
Aye.
Daniel Moore,
Aye.
Rob Vance.
Aye.
Motion passes. That concludes this rulemaking hearing. Following this hearing, the rules will be held for additional comments and or rerouted for any substantial changes, substantive changes. But if not, then put on the rulemaking filing form SS7039, submitted to the governor's office for final review, and then submitted to the Attorney General's office for review and approval. Once the Attorney General's signature is obtained, these rules are filed with the Secretary of State and generally become effective 90 days from the date of filing after receiving a positive recommendation from the Joint Government Operations Committee. Thank you for being here today.
Thank you, Mr. Lott. And I know that you've spent a lot of time on this. I know that Jen has. Kyle, I'm not sure your involvement, but I know Mr. Lott consulted with you today some, so thank you all for all of your efforts. And also need to recognize Mr. Greaseback. I know you spent some time on this, a good bit of time on this also, so thank you very much for that. Mr. Lott.
Mr. Chairman, just to clarify for the court reporter, Ms. Tolan, that is the conclusion of the hearing, and we don't need any further transcription. So you are released if that's okay with you. And if you have any questions, but feel free to ask me later.
So here's a question for the board. Do we need a break now, or do we want to go to the next agenda item? Does anybody need a break? Okay. Then we'll welcome Kara Fitzgerald. Kara, as I mentioned earlier, is the president and CEO of the Tennessee Society of CPAs. So Kara, thank you for spending time with us today.
Sounds like it's. Can you hear me? Are we good? Okay. Okay, sorry about that. Good morning, board. Good to see all of you. Again, thank you for the invitation to present today. I'm going to just update you on a few activities and matters of TSCPA. We have just wrapped up our fiscal year end as of March 31st. I want to update you on some things that might be of interest to the board and the public. We wrapped up our fiscal year end with just over 10,000 members. We did see really great growth in our new members this year, which is encouraging for the society as well as the profession as a whole. We had over 800 new members that are non-student members and over 600 new student members. So very encouraging for our pipeline of future CPAs coming into the profession. We typically update the board on peer review activities since we do administer the peer review program for the Board of Accountancy. As of fiscal year end, we had 424 firms enrolled in the peer review program. During the fiscal year, the peer review, TSCPA peer review committee accepted 97 peer review reports. We typically do a more detailed update for you all at some time in the year. So we'll work with Jen to see when she might want us to deliver that report. Also, the peer review program went through our annual administrative oversight, which the AICPA performs. We received a clean administrative oversight report this year. So that was good news as well. I know Mr. Lott is going to provide a legislative update later in your agenda, so I won't go into great detail on the session, which is, of course, has now adjourned. They came back into a special session, I believe, today, but do want to update you just on a few advocacy efforts that TSCPA was focused on over the last few months. We did host our annual Day on the Hill in January. That was a great success, getting members from across the state of Tennessee here in Nashville to visit with our policymakers. During the Day on the Hill, we spoke with legislators in support of a bill that the Chamber of Commerce was actually leading on related to bonus depreciation in an effort to align Tennessee's treatment of bonus depreciation with the federal treatment. Unfortunately, that was not funded in the budget, and so that bill did not pass. We also provided some clarifying language on another bill related to Bitcoin and what type of report would be required of custodians. And so that bill did not pass as well, but we were involved in just providing some educational and talking points to legislators to clarify some information in that bill related to SOC report requirements. We've spent a lot of time over the last couple of months after Winter Storm Fern, which occurred in January, impacting Middle Tennessee, as well as some other parts of the state, Following the passage of the Filing Relief for Natural Disasters Act in July, the process and the way that states can get extensions of tax filing deadlines after a disaster changed. It was certainly a learning process for those of us at TSCPA, learning about that new process and understanding what we needed to do. Ultimately, we submitted a request to Governor Lee's office to ask them to consider filing a request with the Secretary of the Treasury for Tennessee to obtain an extension of time to file following that winter storm, because so many were impacted with loss of power, damage, things of that nature. We are very grateful to Governor Lee for submitting a letter and ultimately obtaining that extension of time to file. We received an extension to May 22nd for the 23 counties that were named in the original emergency declaration. Later on, just at the deadline of April 15th, the IRS then granted an extension, an additional extension to June 8th for all of Tennessee. So I know that provided some much needed relief to Tennesseans. And again, we're very grateful for the cooperation and the work of Governor Lee and his staff in working with us on that. Moving on, just to update you on the state-specific ethics program, which, as most of you know, TSCPA has a memorandum of understanding with the Board of Accountancy to create that course on an annual basis. And so we worked once again this year with Dr. Perry Moore, who's a faculty member at Lipscomb and has taught state-specific ethics for many years. We worked with him on the creation of that course, updating it based upon the outline that you all approved, I believe, in October. Jen was a great help in that process as well, helping us to gather information that was needed for that course. So that course is now live as of April 1st. Moving on to some just pipeline related initiatives that we have happening at TSCPA. Earlier this year, we awarded our first ever CPA exam scholarships. So our board approved a new scholarship program. Typically, our scholarships have supported students who are pursuing accounting degrees. This particular program actually provides funding to CPA exam candidates, so it will help to alleviate some of their testing fees, review course materials, things of that nature. We initially awarded $4,000 in February, and we will have another cycle of awards that will happen later in the summer this year. We are also excited to announce the launch of a new program called Destination Tennessee CPA. This is a CPA exam review cohort program that we are launching on a pilot basis here in Tennessee. We're working with a company called Exam Prep AI to offer study materials. It's an online learning platform. It will provide a sense of community for candidates in Tennessee to be able to gather with others who are also studying for the same section. There will be some opportunities for individual one-on-one kind of coaching, check-ins, accountability, things of that nature. So that will launch later in this summer. After the initial pilot period, we will see what adjustments we need to make to the program, and then we will launch it more broadly after that. But we are very excited to be able to offer that in support of future CPAs. In May, in just a couple of weeks, our delegation of Tennessee CPAs who serve on the AICPA Council will travel to New Orleans to attend the May spring AICPA Council meeting. We are looking forward to getting some updates on a few items at that meeting. One of those will be a proposal to move certain investigations out of the AICPA Professional Ethics Division process, which some of you are familiar with, and incorporate those into the peer review program. The thought being that that will create a more timely process and more efficient process. The AICPA Council will vote on that matter in May. We also look forward to hearing more about the AICPA's Profession Ready Initiative. This is a program that AICPA, or an initiative that AICPA has taken on to identify gaps in education to the skills that young professionals or new staff need in the workplace. And some of the outcomes I believe that they expect to come out of that program will be teaching resources, things of that nature to help close the gap between education and practice. We also look forward to May 19th, which is National Accounting Day. If you did not know that, AICPA will be celebrating National Accounting Day alongside many state societies in kind of advance of the launch of their CPA Trust campaign. So many of you are familiar with the need for a campaign to build trust of our profession, to help build an awareness of all of the things that a CPA does outside of just audit and tax. And so on June 9th, AICPA will launch that CPA Trust campaign with really two distinct audiences, one being business leaders who work with CPAs, and the other being the CPA profession as a whole. So we look forward to supporting AICPA in that campaign. In closing, I want to invite all of you to TSCPA's 95th annual meeting and convention, along with all licensees in Tennessee who are invited. It will take place in Isle of Palm, South Carolina this year. It's a great mix of continuing education opportunities, networking, fundraising for our scholarship program. And one of the most exciting things that we do at convention is honor the TSCPA Apex Award recipients. And I'm happy to let you know that Mr. Griesbeck will be awarded a Lifetime Achievement Award this convention. So we will be very excited to have him and his family join us at convention to receive that well-deserved honor. With that, I'm happy to answer any questions that the board may have.
Kara, thank you very much. You, of course, are aware of the peak exposure draft on alternative practice structures, and most of the information I get is from NASBA and groups related to NASBA on that. But so my question is, has the TSCPA responded to the exposure draft, or have any of the state societies responded? Do you know?
I know of one state society that has issued a comment letter in response to the exposure draft. I don't know of others. There may be. TSCPA has not issued a comment letter. We don't plan to at this point. I think that's something that firms are probably best positioned to respond to. And then, of course, whatever comes of that, TSCPA will obviously educate our members and support that, but we don't have plans to issue a comment letter at this time. Thank you.
Any more questions, comments? No? Also see Katie Cheek in attendance. Katie's with the TSCPA also. Katie, I can see you now. Yeah. Thank you for being with us today also. So,
Can I make one comment
absolutely.
right here?
Oh, absolutely.
I wanted to applaud the TSCPA on the work that they're doing, especially in attracting new members. Many professional organizations are struggling with that, so that is really encouraging, especially in our state, to see those numbers.
And it's amazing the number of scholarships and scholarship dollars that the TSCPA provides. So thank you for that. I did receive a request that we have a break, so maybe 10 minutes. Sound good? Okay. Thank you. Thanks, everyone, for being back. At this point in the agenda, we'll turn it over to our Executive Director, Jen Beakley.
Good morning, board members. In your meeting materials on your iPads, you'll find a copy of my report. I will now share that with you and will be available for questions throughout. So please feel free to jump in if you have a question. Future meeting dates of the Tennessee State Board of Accountancy. So at the last board meeting, there was interest expressed by the board in reducing our meetings from a 2-day meeting model to a 1-day meeting model. There was also interest in, or there was discussion at least, about moving them to Monday instead of Tuesday. So you'll see in here, I have proposed 2 new meeting dates in 2026. These were both previously committee meeting dates on the calendar. Monday, August 3rd, 2026, and Monday, November 2nd, 2026. And those will be up for a vote at the end of my presentation. The board does not have to move them to Mondays. You're welcome to keep them on Tuesdays, whatever best suits your schedule. I've also included 2027 proposed meeting dates. You'll see here, again, these I have initially presented as Monday dates. February 1st, 2027, May 3rd, 2027, August 2nd, 2027, and November 1st, 2027. And that very closely aligns with the cadence of meetings that we've held in 2026. I'll include a brief report on upcoming NASPA meetings. The 2026 Western Regional Meeting is upcoming at the end of June in Park City, Utah. We have 6 board members approved to attend, including as well as myself. And NASPA has awarded scholarships for 2 of our new board members. NASPA generously offers scholarships for most of the costs associated with travel to these events for any new board members who are appointed after July 1st of each year. So we're excited to have Mr. Bryant and Dr. Hart attending with us, and NASPA supporting us financially with some of those costs. In addition, we have the 119th annual meeting coming up at the end of October in Litchfield Park, Arizona. We have not yet started planning travel for this, but we will soon. As a reminder, the budget allows for 5 board members to attend the annual conference, as well as myself. So if you're interested in attending, please let me know in the next month or so. Yesterday, we sent out CPE audit notifications to 602 licensees who are selected for a CPE audit this year. As a reminder, that includes board members and board staff who are CPAs every year that or every 2 years that your license is up for renewal. You will also be included in the CPE audit pool. It's a privilege of being on the board to get to participate in that. And I'm excited to share that as of this morning, we've already received 105 of those CPE audit submissions. So 105 of 602 have been received, and people are on it this year. I included in Exhibit 1 a copy of the board's response to the NASPA white paper on alternative practice structures in private equity that the board reviewed at the last meeting. As requested by the board at the February board meeting, board staff submitted a letter to the NASPA Private Equity Task Force in response to the request to comment on the alternative practice structures in private equity white paper. As I mentioned, a copy of that letter was submitted on behalf of the board and is included in Exhibit 1. Lee and I recently attended the 44th annual NASPA Conference for Executive Directors, Board Staff, and Legal Counsel at the end of March. Executive directors, board staff, and legal counsel from boards of accountancy throughout the United States came together for the 44th annual conference for executive directors and board staff held March 24th through the 26th, 2026. As I mentioned, Tennessee's delegation consisted of myself, executive director Jen Bickley, and our board counsel Lee Lott. I've included a few bullet points in here on notable updates. First, there was a robust discussion of the AICPA peak exposure draft led by Jessica Luttrell, NASPA Director of Professional Standards and Research, and Steve Plateau, who's a JD and CPA and a University of Tampa professor and NASPA Director at Large. I have also included NASPA's response to the AICPA exposure draft in Exhibit 2 to my report. NASPA shared a brief legislative update. They continue to monitor legislation impacting boards of accountancy across the 55 licensing jurisdictions. At the time of the ED and legal conference, there were 6 jurisdictions where the 120 plus 2 pathway to licensure had not been introduced in legislation. As Kara, I'll repeat something Kara already shared. There was an update from the AICPA on enforcement matters. The AICPA Professional Ethics Division is proposing to shift investigation of certain ANA and related independence complaints from the AICPA Professional Ethics Division into peer review. AICPA staff believe this will enhance ANA quality for impacted firms through more effective and timely remediation. The proposed shift to peer review will change the nature of the investigation and remediation by focusing on the subject firm's system of quality management and the root cause of the issue, rather than focusing on just the individual subject to the complaint. Investigations and resulting remediation are expected to be completed timelier than the current investigation timeline of 2 to 5 years. NASBA also shared a CPA exam update. Bill Emmer, who's the NASBA COO, and Mike Decker, the AICPA VP of CPA Examinations and Pipeline, shared an update regarding the CPA exam pipeline. They reported that CPA exam section volumes are up, first-time unique and CPA exam passers, meaning individuals who've passed all 4 sections of the exam, are up, and that pass rates are consistent and increasing nationally. We see the trends in Tennessee to be consistent with what's occurring nationally. NASBA also highlighted the CPA mobile app, which launched in September 2025. We also heard an update from the AICPA on peer review, specifically with APS focus. On June 1st, 2026, the AICPA will launch a new annual questionnaire for all ANA firms enrolled in peer review. The questionnaire will be short, with 5 questions for firms to report on their involvement in certain emerging areas, including engagement types and industries. Completion of the questionnaire is required. Firms that do not complete the questionnaire will be subject to the drop process. The AICPA has communicated that the intent of the questionnaire is to provide firms with faster delivery of resources and guidance to assist firms in being prepared to perform and report in accordance with professional standards. In addition, effective for peer reviews scheduled for February 28th, 2026 or later, peer review of APS firms will be temporarily reassigned to the National Peer Review Committee for administration of their peer review, rather than their local or regional administering entity. The AICPA APS task force will evaluate the results and develop training materials based on the results of those peer reviews. The AICPA has commenced training for reviewers, technical reviewers, and report acceptance bodies involved in the process. In addition, the AICPA has developed an APS checklist to assist reviewers. The checklist will include review of a firm's APS model and the relationship between the attest entity, non-attest entity, and other parties related to the investor entity. And finally, we heard an update from the CPE task force. NASBA and the AICPA created the CPE task force in 2025 to review CPA continuing education requirements for relevance and effectiveness. Members include representatives from both organizations' leadership, as well as representation from boards of accountancy, CPA firms, state CPA societies, academia, and the public for broad perspectives. The task force expects to have evidence-based recommendations for exposure in Q4 of 2026. Fraudulent use of title. Fraudulent use of the CPA designation, particularly non-CPAs impersonating licensed CPAs using stolen credentials, is an emerging trend affecting multiple jurisdictions. In response to concerns raised by state boards of accountancy, NASBA sent letters to 2 major freelance marketplaces, including Fiverr, who has been not the subject of some of our complaints, but a source of these sort of complaints in some of the recent cases that the board has heard, requesting stronger oversight of users claiming licensed professional status. Over the past 12 months, the Tennessee State Board of Accountancy has investigated multiple cases involving individuals hired through these platforms who were found to be impersonating CPAs. NASBA has indicated that the freelance marketplaces it contacted have expressed varying levels of willingness to cooperate with these requests. Next, you will see in Exhibit 3 that I have provided a financial update of the Tennessee State Board of Accountancy through the end of March. And let me flip back to that exhibit. As I mentioned at our previous meeting, we could not yet see at that time the impact of our revenue generated from CPA license and firm permit renewals, which is the bulk of the source of this board's revenue during the year. So you can see now that November, December, January, those amounts have come through as we anticipated. And I believe that through the end of the year, we are still projecting to be in a deficit position at the end of the year, but it should be very small especially compared to where we were last year. That could change if we continue to see more and a continued uptick in our number of initial licenses issued. All right, self-sufficiency hearing. Greg already mentioned this earlier, but I will repeat it. I think it's worth hearing. Representatives from TDCI and the State Board of Accountancy, including Reed Witcher, who's our Assistant Commissioner for the Division of Regulatory Boards, myself, and Chairman Gilbert attended a self-sufficiency hearing before the Joint Government Operations Committee on Thursday, February 19th, 2026. By statute, any regulatory board that operates at a deficit for 2 consecutive years is required to be reviewed by a joint evaluation committee during the legislative session following the second consecutive year of deficit. Since the Board of Accountancy had deficits for FY24 and FY25, we were required to attend a hearing this year. No action was taken by the committee as a result of the proceedings. And then lastly, you'll see that I included some statistics from our calendar year 2024, 2025, and Q1 of 2026 CPA exam pass rate information. As you can see, consistent with national trends, we are ticking up in terms of pass rates and the number of tests being taken. I also included performance metrics for our team in Q1 2026. We had a 99% customer service rating, and our average number of days to initial licensure was 6 days. I also included some data that shows the number of licenses and firm permits that were issued as compared to previous years. You'll also see on the under licenses issued in Q1 2026, that includes 13 CPAs who have been licensed under the new 120+2 pathway in Tennessee. And lastly, just for reference, I have included a snapshot of our licensing numbers as of the end of March, as well as comparison to previous periods. And I think I believe I've already communicated this to the board, but this past year's renewal cycle, we added a question to firm permit applications asking firms to self-identify if they were operating within an alternative practice structure. We have also added that question to our initial firm permit applications. So we believe we have approximately 21 firms representing approximately 43 firm permits in Tennessee who have self-identified that they are operating as an alternative practice structure. And that concludes my report, and I'm happy to take any questions.
Quick question. Did NASBA have any thoughts on the market improvement in the pass rates recently in the last year or so, or just everybody's doing better?
I think in general, candidates are getting better acquainted with the new model that rolled out, having the discipline sections available. Candidates are getting more comfortable with the content in those discipline sections and a study plan, was my understanding. I think I have also heard anecdotally that college enrollments are up, the number of accounting, I see Dr. Hart nodding her head, the number of accounting graduates is ticking up. So I think there are a few things that are contributing to that, increase.
Mr. Chair, I just have a question, may not can answer. The self-sufficiency hearing, what's that like?
I think Greg can get with me. Greg, I'm teasing. So the self-sufficiency hearing, the Joint Government Operations Committee of the Tennessee General Assembly convenes, and they review all boards that, even boards outside of regulatory boards, health boards, other boards that meet this criteria to go before them. And essentially we present a very brief overview of, here was our position. We have, for the case of the Board of Accountancy, we have a reserve balance that's sufficient to continue to cover this deficit. And they may ask questions as to how we got there or what the plan is to remediate it. But essentially for the Board of Accountancy, the last 2 years, the answer for us has been we have a sufficient reserve, and we don't foresee in the immediate future a fee increase, like a need for a fee increase as we continue to work through that reserve. Mm-hmm.
It was a very interesting hearing. Typically, Reed Witcher and Jen answer questions that the Joint Ops Committee members may have. And if you've been in the meeting room, it's like a huge courtroom with the Government Ops Committee up in the choir loft, so to speak. But so Jen and Reed were at the table. I would call it the witness table, answering questions. And I was back a row, and Senator Seal actually asked me to come up, and he had some questions for me, and which I'd really not prepared to talk. I knew the answer to his questions, fortunately, but I'd not prepared to speak. But it was quite interesting, and I think in part probably what he wanted to do, unfortunately I remembered to do this at the end, was he wanted me to thank him for attending our last board meeting. If you recall, he did that. But he used that as an opportunity to call me up so that I could say that. That's what I suspect. But anyway, Brad?
Yeah, I just want to make a point. Those hearings are normally telecast, broadcast online, and I've watched several of them, but you can go on and watch them. And if a notice is sent out ahead of time for those board members who would like to see Jen and the chair in action, it's quite a sight to see them squirm.
I will mention it. I think it's important for the board to know this. I think most of you know it, but this might be a good reminder for you. We have operated the last 3 years or so in a deficit position. And one of the representatives commented that of all people, all boards that are regulated, that the accountancy board should know how to have a balanced budget. And we do know how to have a balanced budget, but what happened, and this is what's important for you to know and remember, is that a few years ago, maybe in 2022, something like that, the legislature commenced a study for compensation, a fair market value compensation study. And so the compensation for many of the boards, including ours, increased substantially, which at that point threw many boards into a deficit position. And this board has talked about increasing fees, renewal fees and so forth to put us back into a balanced position. And I think, I've not been told this directly, but I think the administration's preference is that at this point, we have adequate reserves and to not increase the fees. So we're in a situation where we don't increase the fees, but our costs are up. And so, but we do, as CPAs, know how to do a balanced budget. But anyway, that was a very interesting hearing. Other questions or comments? We have an action item, I think, to approve the proposed meeting dates. And I had mentioned this to Jen. I have a conflict on the February 1st, 2027 meeting and will not be able to be here. And that's not necessarily important to you, but the question is, does anyone else have a conflict? Because we do need a quorum on that date. Any known conflicts? Which date is that? The February 1st, 2027. And then Jen, you checked with the NASBA about the November 1st meeting. We're good with that.
Yes, so the annual meetings typically, I did not check with them directly to see if they scheduled the 2027 annual meeting, but those meetings do typically fall the last week in October.
Yeah.
So I don't think we would have a conflict with November 1st.
I mentioned to Jen, I know I've been at NASBA annual meetings on October 31st or traveling home from NASBA meetings on October 31st. So I just wanted to make sure that we're good with that. Okay, so is there a motion to adopt the proposed meeting dates?
Motion to adopt.
Motion, second?
Second.
Second. Roll call.
Sam Bennett,
Aye.
Brad Buchanan,
Aye.
Michael Bryant,
Aye.
Brad Floyd,
Aye.
Gregory Gilbert,
Aye.
John Griesbeck,
Aye.
Amelia Hart,
Aye.
Daniel Moore,
Aye.
Rob Vance.
Aye.
Thank you. Jen, I misplaced my notes. Are you going to talk us through the reinstatement application?
Yes.
Okay,
I
thank you.
will. Okay, so in your meeting materials, you have a packet on a reinstatement application for Mr. James Parrish, who has joined us online. He has requested reinstatement of his closed CPA license. I did include an updated memo on your iPads in case you happen to bring a printed copy. I will read this overview, and then the request for the board will be to review and consider the reinstatement application made by Mr. Parrish. So why is this item on the agenda? Mr. James Parrish is requesting reinstatement of licensure pursuant to the terms of a consent order entered by the board on July 31st, 2023. Mr. Parrish first obtained his CPA license in Tennessee on October 30th, 2015. At the close of his 2020-2021 license term, he submitted a renewal application stating that he had completed all required CPE during the 2-year reporting period. Mr. Parrish was subsequently selected for a CPE audit, and he was found to be non-compliant. He was short by 45 and a half CPE hours and failed to meet 4 specific CPE requirements. Board staff communicated the noncompliance on August 31st, 2022, and assessed a total of 32 penalty hours to be completed by November 29th, 2022. In addition to the hours he was found to be short for the reporting period. Mr. Parrish did not complete all of the penalty hours or the missed hours from the 2020-2021 reporting period by the deadline of November 29th, 2022, and a complaint was filed by board staff on January 11th, 2023. The board initially reviewed this complaint at the May 2023 board meeting. At that time, the board authorized a settlement with a civil penalty of $1,500 for failure to meet CPE requirements for the reporting period under Board Rule 0020-05.031AB and for a violation of Board Rule 0020-03-.04 integrity and objectivity and Board Rule 0020-01.08, 4, and 5, submission of renewal applications with evidence of completion of CPE. The case was re-presented to the board at the July 2023 board meeting after Mr. Parrish offered to voluntarily close his license due to personal life circumstances and his inability to come into compliance with CPE requirements in a timely manner. The board approved the recommendation to accept his offer to voluntarily close his license as represented. To finally resolve this matter, Mr. Parrish and the board executed a consent order on July 31st, 2023. In this consent order, Mr. Parrish expressly agreed with all of the facts stated above, and he agreed to voluntarily close his CPA license. I have included a copy of the consent order in this packet for reference. The board has now received an application to reactivate the license, including the CPE credits required for reactivation and the payment of the application fee. Mr. Parrish has joined us today remotely. I can see him on the screen back there. Hopefully you guys can see on your screens as well. So like I said earlier, the request before the board today is to review and consider the reinstatement application made by Mr. Parrish. And Mr. Chairman, I will hand it back to you at this point.
Thank you. I suppose that this is the time for the board to ask questions or have comments to Mr. Parrish. So would anyone like to present a question or questions? Mr. Parrish, while our board members are thinking through possible questions, what were the circumstances when you submitted your CPE and had not really complied with the CPE requirements? Can you talk us through that situation?
Yes, sir. Thank you. At that time in my life, my wife had some significant mental health issues that added a lot of chaos to my personal life. I was also working a lot of hours, past 40. Was not quite as organized as I could have been. Probably after about a year of decline of mental health, she ended up committing suicide, leaving me to be the single father of a six-month-old boy, my son, June. Long story short, kind of had to redo my whole life at that point in time. I did make my best efforts to sort of catch up, but I realized that I wasn't really in a good position to sort of maintain my CPEs to the standards that are required. And since then, I've gotten a more stable job, a sort of a standard 9 to 5. Last year, I completed my master's degree with a 4.0. I have made a lot of simplifications and in my personal life as well as gotten significantly more organized.
At the time you submitted your license renewal, did you think that you had completed the CPE and just didn't go back and double check it, or
I
how did
believe
that?
that I had, but of course I did not have all the documentation, which of course, I was non-compliant. So I did attempt to answer as honestly as I could, but I couldn't support those answers.
Sure. Thank you. Questions or comments?
Just a clarification, Jen, the purpose here is to approve the application for reinstatement. Is that right? That everything's there, or are we actually approving reinstatement?
Because this was not a suspended or a revoked license, you do have the authority to, and it's because it was specifically outlined in the terms of this consent order. The consent order contained language that included this. The respondent agrees to immediately close his CPA license with the Tennessee State Board of Accountancy and to appear before the board should respondent seek licensure reactivation in the future. So that is why this request is before you guys. We get reinstatement applications with some frequency, and we have the authority to review and approve those as board staff. That is why this one in particular is before you today.
Anyone else?
Is there a recommendation from legal counsel or staff on this at all?
Mr. Floyd, I don't have a recommendation.
My recommendation would be to approve it. Can I say that?
Yeah. And Jen had shared that with me, but I wanted her to tell you and not me to tell you that that was her recommendation.
So Jen, all the CPE has been caught up. Everything is in.
So he has, Karen, correct me if I'm wrong, he has submitted CPE that is required for reactivation of a closed license, which would be 80 hours of technical CPE earned 24 months. Yes, that's what I thought. In the 24-month period leading up to the application for reopening the license.
If there's no further discussion, I'd make a motion to approve the reinstatement.
Do we have a motion? We do have a motion. Do we have a second?
Second.
Second. Those in favor of approving, roll call vote, please.
Sam Bennett,
Aye.
Brad Buchanan,
Aye.
Michael Bryant,
Aye.
Brad Floyd,
Yes.
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Amelia Hart,
Aye.
Daniel Moore,
Aye.
Rob Vance.
Aye.
Thank you, Mr. Parrish. I think that's good news for you, and we were very sorry that you've been through the difficulties you have. Our thoughts are definitely with you, and I know that mental health is a very tough illness, and but we're glad to approve your reinstatement request. So thank you.
Thank you all. And I assure you, I won't have any compliance issues in the future. I guarantee it.
Very good. Thank you. Okay. We will move to licensing matters. Chairman Bennett, are you leading this or?
Consistent with the practice that we started last meeting. I think we're going to have the executive director walk through each of the 4 requests that we received over the last quarter.
Yes, I'm happy to do that. I'm sorry you guys have to listen to me talk so much today. So before you today, we have 4 requests for exam credit extensions. Included in your meeting materials were a brief memo summarizing the candidate's request. For each candidate request, I have also included their score history that you can see. And then for some candidates where they included a letter directly to the board, I have included that in the materials as well. I will read the summaries. I am not going to read into the record the individual letters because you have them there before you. All right, so starting with request number 1. For all of these, why is this on the agenda? A Tennessee CPA candidate has requested that the board consider a 2-month extension request of his FAR score from an expiration date of April 9th, 2026 to July 31st, 2026. This candidate contacted the board on February 25th, 2026, requesting an extension of his FAR score, as I said, from an expiration date of April 9th, 2026 to July 31st, 2026. The candidate provided the attached letter detailing several life events that have impacted his ability to appropriately study and prepare for the CPA exam. Notably, this candidate has passed FAR twice, in July 2021, for which the credit has expired in September 2023, which is the subject of this request, and has also passed audit and reg, for which credit will expire on June 15th, 2028 and October 8th, 2028, respectively. He has shared with me that he sat for his last section, ISC, which is a discipline section, on April 7th, 2026, and awaits a June 2026 score release. So it is possible that he may not need an extension if he passed that section. All right, request number 2. This Tennessee CPA candidate has contacted the board on March 5th, 2026, requesting an extension of his reg score from an expiration date of March 16th, 2026 to June 26th, 2026. The candidate has been under the care of a health professional for a mental health condition since October 2025. The candidate's healthcare provider provided a letter of clinical confirmation confirming the existence of the condition, the impact on his ability to appropriately prepare for the exam, and the timeline noted by the candidate. Notably, this candidate has also passed BEC. The requested extension for reg would bring the expiration date to align with the expiration date for his BEC score. It appears the candidate has a valid notice to schedule for FAR that expires on October 19th, 2026. So that means that he's been approved to sit for FAR, but I don't believe that at this last I checked, he had not scheduled his exam, or I couldn't see it if he had. All right, request number 3. This candidate contacted the board on January 31st, 2026, requesting an extension of her FAR score from an expiration date of March 31st, 2026 to December 31st, 2026, due to the closure of a Prometric testing center in Greensboro, North Carolina, at which she was scheduled to take TCP on January 31st, 2026. The test center was closed due to winter weather conditions. Of note, discipline sections of the CPA exam, which include TCP, BAR, and ISC, are only offered during testing windows as opposed to continuous testing. And those windows are currently offered the first month of each quarter. So January would have been the only time that she could have tested in Q1 of this year for that section. In response to the January winter weather-related test center closures, NASBA, the AICPA, and Prometric extended the testing window for discipline sections through February 3rd, 2026 for the states impacted. The testing window for these sections would have otherwise closed on January 31st, 2026. The candidate stated that she received an error that testing wasn't available when she attempted to reschedule with Prometric in February. The candidate cited the following in support of her request. Due to the recent winter storms and the subsequent declaration of a state of emergency, I was unable to sit for my scheduled exam nor continue my studies. The emergency situation caused power outages and closure of the local Prometric Center. I have left my home only once over a period of 10 days and counting. I am fully committed to completing the CPA examination process and am requesting a 9-month extension to allow me to reschedule and sit for the exam safely. Additionally, to accommodate the disciplined CPA exam score release schedule. Of note, the board has previously approved an extension for this candidate's FAR score from June 30th, 2025 to March 31st, 2026 due to documented medical issues in 2022, 23, and 24. The candidate passed FAR on August 11th, 2022. Notably, this candidate has passed REG, for which credit will expire on February 6, 2028. She sat for TCP on April 4th, 2026, and awaits a score release in June 2026 for that section. She is planning to sit for audit in June 2026 and appears to have an approved notice to schedule for audit that is valid through September 2026. She expressed that the cancellation of TCP in January created a delay in taking audit. And the last request number 4. This CPA exam candidate contacted the board via his father on April 24th, 2026, requesting an extension of his BEC and audit scores from an expiration date of June 26, 2026 and April 30th, 2027, respectively, to June 30th, 2027 for both sections. The candidate provided a signed letter detailing his health issues related to a severe mental health disorder that have been ongoing for several years. After a medical review, this condition caused the candidate to be placed on disability with his accounting firm employer in April 2025. He ultimately chose to resign in November 2025 to focus full-time on getting well. He is currently undergoing an intensive outpatient program with a healthcare provider. The candidate has also requested an accommodation of additional time, and we have directed him to NASBA's ADA team, who's responsible for coordinating that with candidates. The candidate provided a letter signed by the candidate detailing the condition, as well as a letter from his healthcare provider confirming the nature and timeline of his experience. Notably, this candidate has attempted FAR and REG and was just short of passing both sections. He supposed that he may very well have been able to pass the remaining sections if he had not lost time managing his symptoms during those tests. So for all 4 of these requests, the task before the board this morning is to review and consider the extension requests made by each candidate. And I'm happy to answer more detailed questions on any of these if you have them, because that was a lot of information. Thank you.
Thanks, Jen. So from my perspective, these appear to be reasonable accommodation requests that are circumstances that are contemplated under the board rule. Do we have any discussion or comment? If not, I'll ask for a motion to approve.
So moved.
Second.
Oh,
Sam Bennett,
Aye.
Brad Buchanan,
Aye.
Michael Bryant,
Aye.
Brad Floyd,
Aye.
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Amelia Hart,
Aye.
Daniel Moore,
Aye.
Rob Vance.
Aye.
thank you. That concludes the licensing matters for today's agenda.
Thanks, Jen. As I noted earlier, Mr. Bonner is not able to be with us today, and Mr. Vance has agreed to serve as chair for our legal report, and I think Mr. Lott is going to present the cases, but Mr. Chairman?
Thank you, sir. As in the past, we have the legal memorandum divided into 3 major sections. The consent agenda, which has each one of them except one has some recommended, or I guess closure on all of those. Maybe there's a letter or 2 of warning, but there's no actual monetary enforcement, if I recall correctly. We have 3 proposed discipline, 3 with proposed discipline, and 3 with re-presentations. So we have a total of 22 cases. And as we started a few meetings ago, we have our legal counsel here, Lee Lott and Kyle Johnson, to describe each case that they administered. And Mr. Lott, you're up first. And so if you would please carry on.
Yes, sir. So this first section, I have 8 cases to present. And then Mr. Johnson has an additional number of cases to present. And just to clarify, this is the consent agenda. So these are items where the board is not being, where staff is not recommending that the board authorize the commencement of formal proceedings. So that's essentially what's going on. That's why the recommendations are things like close, letter of warning, defer, litigation monitoring, things like that. And then the next section, which we'll discuss later in the meeting, has some proposed discipline, which would really, that's the title of the section. But again, it's the vote that the board that is recommended is to authorize the commencement of formal proceedings. So that's in the next section. In the current section entitled Consent Agenda, the first case, number 1, the complainant alleges failure to perform tax prep services. There was a fee of $600 paid and refunded. The parties resolved their dispute over the tax prep services and $600. I will note, dispute over fees is not within the board's jurisdiction. Also, if there's a dispute and it's settled, the settlement between a complainant and a respondent doesn't necessarily resolve the matter for the board's purposes. The board is free to look at any violation that has occurred, whether or not a settlement was reached privately in some amicable way. Certainly a factor, though. In any event, in this case, the complainant did make an additional statement. The complainant said, I believe something was fraudulent here. So the board's investigator, Mr. Speed, reviewed the matter. Nothing was identified of a fraudulent nature. There was no violation of the act identified. Accordingly, the recommendation is to close. Item number 2, the complainant alleges failure to pay for construction work. Apparently, the complainant was a building contractor who did some construction work. And again, there was a resolution between the parties, but still the board's investigator looked at the case, and we looked at the facts and did not identify a violation of the professional rules. And so the recommendation is closure. The third item, a respondent, a CPA, demanded a refund of a referral fee and says that he made this demand in jest. And long story short, this respondent paid $300 to get this client to get a recommendation from a former provider. And the client ended up deciding to use someone else entirely. And so the question is a referral, first of all, is a $300 referral acceptable under the rules? The rules do prohibit that under certain circumstances, but not here with the type of work here, tax preparation. In any event, there's also a rule on regarding professional conduct, whether conduct reflects well on the profession. And the recommendation here is that the conduct of joking about a referral fee and jokingly demanding a return of a referral fee doesn't reflect well on the profession. There are mitigating factors here. This particular respondent, this particular practitioner was quite apologetic and said he tried to clarify it, but the person just didn't want to listen. And the complainant didn't communicate with board staff and the investigator really here. So as a result, the recommendation is to close, but with a letter of warning to clarify that joking about such matters doesn't reflect well on the profession. Number 4, this is an unknown respondent. We don't know who this is, and we tried to find it out. But this particular person forged a signature on an attest report. And Mr. Speed even attempted to find the client and get no response. And so despite the investigation, we were unable to identify the identity. We were unable to identify the wrongdoer. And based merely on that, the recommendation is to close. Numbers 5, 6, and 7 are really all the same case. complainants make multiple allegations in a very lengthy and detailed 98-page complaint. And here, a complaint was, this 98-page complaint was submitted, and the respondent received it. And in response, the respondents requested litigation monitoring. The respondent said, please just put this in litigation monitoring because there are other proceedings. There are multiple civil actions in multiple counties that involve these parties and facts. So looking at the 98-page complaint and the allegations of the parties, there is some overlap between the civil actions and the allegations in the case here and the civil actions, but there's some not. But more importantly, the respondent has asked to go straight to litigation monitoring as opposed to completing the process. You know, in our board rules, 020-03.16, a respondent, when given a copy of the complaint, is required to file an answer to the complaint. And they didn't do that here. They asked to skip that part and go straight to litigation monitoring. So the recommendation here is very simple: to complete the process. So ask for a response, let the board's investigator complete his investigation, and then the board can look at this in a future meeting, possibly August or whenever it's prepared. So that's the recommendation for those 3 cases. There are 3 cases listed because there are 3 respondents. And just as a technical matter, a case has to be opened up for each respondent. All 3 of the respondents are licensees, of course. Now, the final case, the 8th case on the legal report, number 8, is one where there was a complaint, numerous allegations, and the respondent looked at the allegations and responded to them as required with an answer. Answered the allegations. And in that case, there is also litigation in the civil court elsewhere, in this case in Indiana. So based on all the facts of number 8, the recommendation there is litigation monitoring. And Mr. Vance, I don't remember how Mr. Bonner likes to do it. I think he probably wants to hear from Mr. Johnson first before having a vote on the consent agenda. You'd have to go through all, yeah.
Yeah, I can pick up on my cases, Mr. Vance. I do want to know number 14 on the consent agenda. I would prefer to take that one out separately and discuss that if that was okay with you.
I agree. We're gonna, yeah, that's the one with discussion.
Yes, that's the
Yeah, I
recommendation
agree.
right now. Okay. So I'll pick up with number 9. That is case number 2025-060-571. This complaint concerned grievances related to tax preparation services against an unlicensed individual. Following review of the complaint and evidence, there were no current issues with the firm name being in violation of statute. And in reality, the tax grievances are outside the board's jurisdiction, given the respondent's not licensed. So the recommendation is to close there. The next one is number 10, that on the lead report, that is case number 2025-076-051. This complaint was filed by a previous employer of the respondent. The complainant alleged the respondent used firm documents for his own business and also improperly solicited firm clients for his own business. Following review and investigation, the evidence indicates there was an employment agreement that authorized respondent to take clients he developed if he paid the firm a fee. When he left, it was also noted that the respondent stated many other accountants at the firm have their own businesses separate from the firm. Additionally, the investigation revealed a lack of evidence that respondent himself used any proprietary documents of the firm for his own personal gain. The investigation did reveal that another individual was the one that potentially modified a firm document. Based on this evidence and the language of the relevant AICPA rules, I do not believe that any disciplinary action would prevail, given the employment agreement would most likely be a defense to a violation of that rule, and there was no evidence that the respondent took any firm documents himself. So the recommendation is closed there. Do we have any comments on that case? Number 11, this is case number 2025-075-951. This was an internal complaint with allegations. Respondent issued a review report without enrollment in peer review or a firm permit. Based on review and investigation, respondent was not involved at all in preparing the subject report, and their name and license was used fraudulently by an unknown individual who solicited services on a website. Number 12, case number 2026-006-041. The complaint alleged respondent was advertising a test services without a license and that respondent's firm name was in violation of statute. Following review and investigation, respondent submitted proof of the firm name now being in compliance with the statute. It was changed. There is no evidence that respondent had issued a report on financial statements for a client that would constitute an attest service. The evidence does indicate respondent is offering, in quote, financial statement analysis and, in quote, auditing on its website, but there's no mention that the financial statement analysis or audit would be performed under the attest standards. Ultimately, the recommendation is a letter of instruction in this case to instruct respondent of the prohibition of offering to render attest services without a license and instructing respondent on the definition of attest services. And we're going to take 14 out of the consent agenda. So I'll move on to number 13. This is case number 2026-004-461. The complainant alleged that respondent had exhibited conduct involving a plethora of ethical violations, really. In response to the complaint, respondent did provide a response and information negating the allegations. In fact, these claims from complainant were the subject of an emergency conservatorship action in state court filed by the complainant. The state court did appoint a guardian ad litem who did investigate the matter. The guardian ad litem found no evidence to support the claims, and the action was dismissed in state court. Additionally, I'll point out, since the respondent is not licensed, the allegations, even if true, are not within this board's jurisdiction. The recommendation for that one is closed. Number 15, this was an internal complaint with allegations. Respondent issued an audit report without enrollment in peer review or a firm permit. Based on review and investigation, respondent was not involved in preparing the subject report, and their name and license was used fraudulently by an unknown individual who solicited services on a website. The recommendation for that case is closed. The last case of mine on the consent agenda, this is number 16, 2026-023-981. This complaint involves grievances with tax preparation services and advice given on tax matters. Based on respondent's response to the allegations in the complaint, there does not appear to be enough evidence of conduct that would amount to any violation of the board's statutes or rules. Respondent's response to the allegations appear to support the position that he did not represent any facts, give incompetent advice, or otherwise engage in any conduct that would rise to a discreditable act under our rules. The recommendation is to close for number 16. And that concludes my cases, Mr. Vance.
I have a question for Jen on I think there are two cases regarding the Board of Licensing Contractors. So when these reports are issued fraudulently, what does the board do then? Do they require that the contractor get a licensed CPA firm to?
I believe they will reject the report received from the contractor.
Yeah.
So, someone please correct me if I'm wrong, which is very possible. Because we did not have committee meetings, and I guess we're not going to have committee meetings going forward, and this was all discussed at the board, we are going to need a motion for the consent agenda cases 1 through 16 minus 14. We're going to discuss that one separately. And so we need a motion to pass these as recommended for the consent agenda.
I'll make a motion.
I'll second.
All right. Proper motion and second, so roll call vote.
Sam Bennett,
Aye.
Brad Buchanan,
Aye.
Michael Bryant,
Aye.
Brad Floyd,
Aye.
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Amelia Hart,
Aye.
Daniel Moore,
Aye.
Rob Vance.
Aye. Mr. Johnson, would you like to discuss 14 now?
I think that'd be appropriate.
Okay.
Let's go ahead
All
and
right.
discuss it. So I'll give you a brief summary, and then my recommendation right now is to discuss, and then based on our discussion, I'll provide a further recommendation after that. But I feel this case needs to be discussed. So number 14, that's 2026-007-861. This was an internal complaint with allegations that respondent issued a review report without being enrolled in peer review or having a firm permit. The respondent is licensed out of state. Based on the review of the report and what respondent claims in defense, this case really boils down to the definition of attest services and whether that report meets the definition. Council believes this case, it should be discussed in conjunction with the relevant definition between all the members. Based on the discussion, again, I'll offer a recommendation, but I will offer that the way I look at the definition, the report, just looking at the report itself, it does not meet the definition because it does not have reference to the appropriate review standards, and that's the way our definition lays out. So I'm not sure I can get to saying they issued an attest report without a valid peer review, because it's really an invalid review report is the way I look at it. But I do want to get you all's opinions.
Does anyone have, I have a comment about this. Does anyone else have a comment about this particular case? Have you read it? My comment would be that I guess technically, yes, this individual didn't comply with the proper language to reference it to SARS. I believe that's correct. And I'm a little removed from the reporting standards myself. I've been out of public accounting for a few years. However, in reading this, it's my opinion that the individual was trying to indicate that she was doing a review. In fact, the language here is, quote, "I confirm to the best of my knowledge and belief the following representations made during review." And one thing I learned a long time ago, almost 40 years ago, accountants shouldn't use certain words. Like, I'm going to examine this, I'm going to review this, I'm going to audit that, I'm going to, and those are the buzzwords that we're, unless you mean that particular, you're auditing them or you're doing a review, you just avoid using those terms if you're in public accounting, because people may think that you're actually doing a particular kind of work. So I think that based on, she's referring to GAAP, she's referring to making the language attempt to sound very official, in my opinion. So I think there should be some sort of discipline here or enforcement on this case. I mean, what is the standard? What's the standard practice for an individual that submits that's not in the peer review program and submits a review report to the state board, saying it's a review report and using the proper language? What does that typical enforcement look like?
If you wanted to go to that route, I almost think a due care violation would be better, because almost she issued an invalid report. She didn't consult with her client. I mean, she offered something that her client, that's not what her client needed. It was rejected by the board of contractors. If you do go that, if the discussion moves to that route of wanting to provide discipline, or I would even consider like a letter of warning. She is based at, it's an out-of-state licensee. You could warn her that the board pretty much considered this a due care violation. You issued an invalid report. Don't do it again. If it comes up again, then you could consider discipline at that point. But I would lean the board, if you're considering discipline or a letter of warning, I'm not sure I can get there with, like, for instance, for a judge, like looking at the laws, that report met the definition in the statute. I would almost feel more comfortable with the due care violation of board rule.
Okay. Due care letter of warning then. So that's, I guess that is well, you're not making that recommendation. Let me make that recommendation, I guess.
I'm a little, these quotations are from the report, so to speak.
Yes.
Is that right? Because I don't really understand what she's doing.
I think according to her,
let me just finish, Kyle, because in one hand, she says, she starts off the language with what you might expect to see in a review report. But then she pivots to say that she's responsible and the auditor or the test is not responsible. That's management's responsibility. So is that why she's saying that there's no attest? Was she issuing this as management as opposed to a third party hired by management?
I don't believe so. I think in her mind, it was what she called a third-party verification, which I really don't know what that is. I mean, and I kind of, have y'all ever heard that term? I don't. Okay.
But, I mean, but it is true. It can't be in a test report if management. I mean, if she's saying that she prepared the financial statements, then it isn't in a test report because it's, you can't self-attest under the professional standard. So
Just a clarification that it does talk about her client.
well, and that's what
So
I'm saying. There's like the wording here is she's conflating, it seems, a number of different things, which is why I'm not sure. Was she trying to issue a report for a client as a third party, or was she trying to issue a report as management, even though she prepared for her client, which is a third party? That's what I'm just trying to make sure as we think about what the proper course of action here, just
The
understanding.
contractor board requires a third party.
Say again?
The contractor board requires a third party accountant report. So it really can't be from management.
An independent,
Yes,
obviously.
correct.
Report. And, okay.
Yeah.
She also says the intent is to express limited assurance that there's no material modifications that need to be made to conform with GAAP.
Which that's a review report.
Yeah, right.
That's like right out of the thing. I mean, it's.
and I don't see how she can extricate herself from the application of SARS. I mean, there's no provision in SARS to be able to do that. Is that,
She also states here, I am providing this letter in connection with the
With review.
Lost my, where does it say that? I am providing this letter in connection with review of the financial statements of X as of December 31, 2025. I mean, to me, I'm think she's trying to be cute with the rules. I mean, that's my opinion.
In this, just clarification, was there any statement that explicitly said this is not a review engagement?
No, there was no statement to my knowledge in there that said this is not a review. I mean, she listed review. It says a limited assurance. I think I'm a little confused as y'all are, is she hopped around some of the language here. So in my mind, that's why she really didn't confer with her client what I'm not sure she even knew what she was exactly doing. So, I mean, that's why I was kind of leaning towards due care. But to answer your question, circle it back, there was no statement that it was not a review report.
I mean, the fact that she's got so much review language in here, she's pulled it out. Seems to me like we could hold her. You were trying to do a review. You mentioned the word review. You mentioned limited insurance, those type things. And then I guess is secondarily, is this something we report to the state she's in?
Yeah, there's only two options, right? It's either a compilation or it's a review. In a compilation, the CPA doesn't take any responsibility for accuracy or completeness of the information. And she specifically says that she's taking that responsibility and providing limited assurance under GAAP. So I think it's hard to make the distinction that she's not attempting to do a review.
I concur.
I mean, I think it's clear that she shouldn't be doing any of those things. And I don't know what the best way to communicate that is.
Do you feel because Kyle, that because she's out of state, does that limit your options? It sounds like to me.
It doesn't limit them. I just think, because she may be out of state and practicing under mobility, she may have not been. She did mention that it's not an audit, which I would agree with. There's no mention of an audit in there. So I'm not sure if her state rules are different. And she was hopping around, but I do feel a letter of warning would be my recommendation. If it happens again, if this situation happens again, we can hit her with a monetary penalty at that point. My only hesitancy is I can't meet I agree with all of it. I can't meet the statutory definition of a review report or a test service in that violation. And then due care is more like a negligence argument, which we can make that argument for sure. And I think it's pretty clear she didn't consult with her client enough about what was needed for the application. So I think if we warn her about that if you issue another invalid report here, we will certainly take action at that point.
I have another question. If we remove the out-of-state factor, what would we be considering?
I think
Or-
again, my recommendations are similar on the side of that this is bouncing the lines of I can't really prove it's in a test report, but I could possibly prove a due care violation. I would, again, it's a hypothetical. I can't for sure say I would still recommend a letter of warning. I do think the reason I bring up that it's an out-of-state licensee is that her frequency of practicing here may not be as high as someone else that is in state.
Yes, I asked that just out of the idea or perspective of setting precedent in this space, or how we would deal with it versus deal with someone who may not be. And in whatever communication does go out, that it somehow aligns with that, even if it is a referral to that other state board of accountancy, but that we have something that reflects a similitude in approach.
I think if you wanted to refer it to that state board of accountants to look into, that would be appropriate as well. I don't think you need to be as concerned about setting a precedent. I mean, each case is viewed differently. If that were to get brought up in a hearing, that would not be relevant. In my, I would certainly object to any discussion of a separate case in a hearing. It's just not relevant. So I don't think you need to be as worried as setting a precedent. I think there's other situations that are similar to this where it kind of bounces around rules where we've, issued a letter of warning in the past.
Does anyone have any more a recommendation of something stronger than a letter of warning?
I would, I like Kyle, where you went about issuing a referral to whichever state board is appropriate, given that this individual, if she's doing it here or he's doing it here, could be doing it elsewhere. And seems logical, at least, that they're not sure exactly what they're doing by virtue of what they've issued. So to protect the citizens of any other state, I would say that's probably a prudent course of action.
Well, I would be happy or welcome a motion for a letter of warning to instruct her on, what she did wrong and to refer the matter to the appropriate, the state board in which she's licensed.
All right, we do need a motion from someone, if so approved.
So moved.
And I'll just make clear from the record, that's my recommendation after the discussion as well.
Seconded.
Okay, proper motion and second. Let's have a vote.
Sam Bennett,
Aye.
Brad Buchanan. Aye. Michael Bryant,
Aye.
Brad Floyd.
Aye.
Greg Gilbert.
Aye.
John Griesbeck.
Aye.
Amelia Hart.
Aye.
Daniel Moore.
Aye.
Rob Vance.
Aye. That gets us through number 16. Now we are into the proposed discipline section, and Mr. Lott, you are up.
Yes, sir. Yeah, and just to clarify that the title of this thing on the report says proposed discipline, but it's these are cases where the council is recommending the commencement of formal proceedings, and then in addition requesting settlement authority if that's appropriate in the board's view. So case number 17, complainant alleges a failure to provide documents requested by the client or representatives by the client in a reasonable time. And long story short, there was a considerable delay there was a delay in providing some documents, and there was a 6-month delay in providing all the documents. There was some argument about a miscommunication there and whether the production was required, but ultimately it was made. It just wasn't done in a reasonable time. And so the recommendation is that the board authorize the commencement of formal proceedings for a violation of board rules. And then the settlement authority requested would be $1,130, consisting of a $1,000 civil penalty and $130 in costs. Now, case number 18, complainant alleges a fee dispute and misconduct. And the investigation didn't reveal violations except regarding the allegations, but it did reveal a different violation. Respondent uses the word accounting in multiple ways, title or designation in identifying itself. And this is a violation of board rules, and therefore there's a recommendation for the commencement of formal proceedings with settlement authority of $500 in civil penalty and $65 in costs for a total of $565. However, further recommendation that amount be reduced to zero if the person who's from another state will simply remove the references to accounting that violate the rules. So that's case number 18, and then Mr. Johnson has number 19.
Yes, number 19, case number 2026-011251. This complaint was opened as a result of respondent being selected for an audit of their CPE compliance. Ultimately, respondent was not in compliance as outlined in the further report that you have. And she did admit to that fact and offered some reasoning behind that non-compliance, which included some medical issues with one of her children. Respondent has voluntarily inactivated her license and cannot practice public accountancy at this time. Given those circumstances, instead of a monetary penalty, the recommendation is to offer respondent a consent order where she agrees to the condition of appearing before this board as a part of a reinstatement application if she chooses to reinstate in the future, and complete the NASBA 3-part ethics course as a part of that application to reinstate her license. And again, if respondent does not agree to that consent order or settlement involving those conditions, the matter could be represented for an authorization of formal charges and a monetary penalty.
We are at the end of the proposed discipline section. Any comments? Questions? So I believe that we will need a motion to accept items 17, 18, and 19 as recommended under the proposed discipline section. But we need a motion in a second.
Rob, I have a question, and I'm sorry I didn't ask that earlier. Jen, on number 19, how did the renewal application work? Did the individual just not submit the CPE listing that we require, or do you know what happened, or maybe Duke knows? I'm not sure.
How did we come about her knowing that she was not in compliance? Is that
right?
Well, she was selected for the audit, and then I guess through that audit process, they asked for proof of her compliance, and she didn't provide all the necessary. And I think at that point they extended it a little bit for her to get back into compliance, give her some time, and she ultimately was not able to do that, and which led to her making her license inactive, I believe.
So more specifically, I think on the renewal application, do we not list the courses that we take and the number of hours?
So licensees do, and licensees are required to attest and answer questions in that renewal application saying, yes, I met this requirement, this room. It's very detailed. And we do not, I think I mentioned this earlier, we do not audit 100% of those listings that come in, even at the renewal phase. Our opportunity to audit is, and to verify the list that they provided is during that audit cycle. So she would have presumably shared her list during the renewal. The renewal would have processed if she indicated that she completed all of those requirements, and we would have only seen it at audit.
So stated a little differently, she provided us a list, but she'd really not attended those courses.
I will mention this as a part of her defense. She did say she completed 24 hours that she thought were NASPA certified, but ultimately were not. She also started a new job in 2024 with the IRS, which entailed a lot of travel and training. I guess she believed that to warrant some CPA credit, and she requested that the IRS provide that necessary information to substantiate that, and they never did when she left. So I think that was part of, it's kind of relevant to that point.
Any further discussion? Questions? All right, we are going to need a motion to pass these three proposed discipline items, 17, 18, and 19, as presented by council.
I make a motion.
Proper motion and second, so roll call vote.
Sam Bennett,
Aye.
Brad Buchanan,
Aye.
Michael Bryant,
Aye.
Brad Floyd,
Aye.
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Amelia Hart,
Aye.
Daniel Moore,
Aye.
Rob Vance.
Aye. Last section, representations. Cases 20, 21, and 22. And Mr. Lott, you are up, number 20.
Yes, sir. So in the case number 20, the complainant alleges breach of trust by a CPA. And the allegation is a breach of trust in relation to the sale of a company. And the facts show that the CPA provided services, CPA services to the complainant for a number of years through a consulting firm. But then in the year, it says it in your facts, I think it's 2020, the consulting firm was closed. And then that particular licensee went to go work for the company. And then a year later, that company, it's actually two companies, the companies were sold. And they were sold on terms that the complainant, I think the fact show made some amount of money, but alleged that there wasn't enough. For whatever reason, the complainant wasn't satisfied with the terms of the sale. And said that there was a violation of, there's a misconduct by a licensee. And considering the facts of this case, the recommendation is going to be that this close, but this was the subject of a civil action that lasted for some period of time and even went up on appeal. And the complainant lost the civil action. That doesn't control what you do, but for what it's worth, the complainant did lose. And the reasoning with the court and the Court of Appeals was that the complainant signed a release, said I can't have a claim legally. So the release was enforced against the complainant. But now the complainant is alleging professional misconduct by a CPA in regards to CPA services. But the allegation, if we look at the actual allegation, it has to do with the conduct of an individual in the sale of a company a year after the consulting firm closed. So the allegations are one of, contract, tort, and those are outside the jurisdiction of the board. So the recommendation for this particular case on representation is to close. The next case is number 21, Ruggieri. Oh gosh, excuse me, I said the name. I'm not supposed to say the name. Well, long story short, the name won't matter. This is a particular licensee who alleges she completed her CPE requirement. She was chosen for an audit. She sent a response. She originally, with the renewal, submitted a list of all her CPE courses. And in the audit, the board staff asked for certificates, and she responded by saying, I believe I've provided everything. I provided a list of everything I took. And didn't say anything else, didn't provide any certificates, didn't provide anything. And one more communication came in and the person said, I think in a second email, I provide everything, I don't understand. And so at a prior meeting, the board authorized the commencement of formal proceedings and settlement authority for violation of CPE requirements. The person just didn't provide. So in working on that, I prepared up a consent order and sent it to the licensee, and I called the licensee. And she can tell you it has a terminal illness. No doctor's note was provided. I did not ask for any confirmation. But after a 30-minute phone call, I determined this person got a terminal illness. Her license is going to expire in 7 months anyway. I'm coming to the board to recommend that this matter just be closed. Now, we're going to look and see if she renews. If by some chance miracles happen, and that would be wonderful if she could renew and resume her practice and overcome this health issue, then we can look at any kind of CPE requirements that need to be addressed at that time. But if she doesn't renew, her license expires in 7 months anyway. And so the recommendation for this represented case is closure. And then number 22, the last case, the complainant alleges CPE violations, in particular that the licensee asked someone else to take the courses. And the complainant alleges mishandling confidential client documents. This again was, these parties were embroiled in civil litigation. Ultimately, the claims were non-suited. The litigation closed. Now, on representation, our board investigator has dug into this and identified no substantial evidence of a CPE violation. Now, as to mishandling confidential documents, some documents were sent over to the board staff as evidence. Some were unintelligible. There were a couple that appeared to be W-2s that were sent over text. And, you know, that alone is the only thing that that board staff was able to identify. And so I think as a precaution, the board should issue a letter of instruction telling the licensee that confidential client documents must be safeguarded under professional standards. But then other than that, close this matter. That's all we have for representation, those 3 cases.
Any comments or questions? Okay, seeing none. Hearing none. I will need a motion to accept the representations cases 20, 21, and 22 as recommended by council. I need a motion and a second.
Second.
Here, proper motion and second. Roll call vote, please.
Sam Bennett,
Aye.
Brad Buchanan,
Aye.
Michael Bryant,
Aye.
Brad Floyd,
Aye.
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Amelia Hart,
Aye.
Daniel Moore,
Aye.
Rob Vance.
Aye. I believe that wraps up the enforcement committee.
Thank you, Mr. Vance. Great job on filling in for Mr. Bonner. And
Those are big shoes.
we have a lot of depth on this board, so we're thankful for that.
Sure.
I was giving our attorneys a second. Mr. Lott, we've kept you busy today, but next on the agenda is a legislative update.
Yes, sir.
I'm sorry. Mr. Griesbeck just pointed, did we do the update on agreed citation process?
Oh, yes, I can address that.
Okay.
We interpreted what the board's vote on that as instruction to proceed, and we've been looking for cases to fit. But there is no such thing as a cookie cutter case, but some do fit the format that kind of some of the pattern that was identified in the board's discussion. Sometimes they fit that pattern, but we haven't seen any good candidates yet. So that's I know the board would have a natural question, well, what happened to the agreed citations? Well, there will be some when the right candidates appear.
Thank you. Now we'll move to legislative update.
So I'll keep this very short. The key piece of legislation that specifically concerns this board is the Senate Bill 1542, had a companion bill in the House 1599, and this legislation extends the sunset date for the board to June 30th of 2030. And this bill was signed by the governor on March 6th, 2026. That's all.
It's great news. Okay. And that's it for the legislative update?
Yes, sir.
Great. NASBA/AICPA updates. Anyone have an update?
I'm happy to share an update. So I serve on the ALD task force. ALD is the accountancy licensing database.
Yep.
Yes. And we are currently working on, that is an application that as board staff, we use almost daily to verify licenses from other states. Some states submit discipline records to the ALD that we can access. Like I said, I serve on that ALD task force, and we are currently reviewing a 2030 vision document for how we would like that tool to be expanded and continue to be used and continue to be beneficial to jurisdictions who participate in sharing data that way. I also serve on the Exam Administration Committee, and I don't have much to report except that we have a meeting coming up later this week for that committee. So more to come.
Thank you, Jen. I think, I'm not quite sure how he's connected, but Andy Bonner somehow is involved with ALD. I think, is he the board member with oversight of that?
He is. He
Okay.
serves on that task force as
Okay,
well.
good. Andy has a full plate with NASBA. He's very involved. Other updates?
The Communications Committee will be, as I've done the last few years, hosting a breakfast at the Western Regional in Park City and also the Eastern, as I recall. And now that we know everyone who's attending that meeting, I have a number of people pre-registered for that breakfast, so you can plan on showing up for it. I'll remind you the night before.
Thank you, John. Others? Each of you should have received an email, probably multiple emails from NASBA, giving you opportunities to sign up for committees, and I know some have done that, and I'm not sure if the date has expired at this point or not, but consider that, at least for the future, provides a great opportunity to be involved with the some of the technical aspects of the profession and regulatory issues and so forth. So I think those committees are really good, actually. Another item I will mention is NASBA held a webinar on February 24th, and I think they may have repeated this subsequent to that, but I attended the one on February 24th regarding alternative practice structures and the peak exposure draft. And as you've seen, NASBA has submitted a lot of information regarding the exposure draft, but some of their webinars are really good. Then I also serve on the Enforcement Resources Committee, and we're meeting at the end of this month in Denver. So I'll have a report for you at our next board meeting on that. Are there any others? Okay, we will move to old business. And we have discussed and rediscussed the peak exposure draft. And recall, as Jen mentioned earlier and is in her report, we submitted a response to NASBA regarding their white paper regarding the exposure draft or alternative practice structures, I should say. And at that time of our last meeting, I suggested that NASBA had better resources than us, not smarter people, but resources with a lot more time than we have to respond to peak. And my personal opinion was, and probably still is that NASBA should provide a response on behalf of all state boards of accountancy. I mean, what is NASBA? And that's the National Association of State Boards of Accountancy. And NASBA provided a very thorough response to the peak exposure draft. However, NASBA has strongly encouraged the states to respond individually. And NASBA feels that it's very important that peak have responses from each of the jurisdictions. I think there are 55 jurisdictions, maybe, Jen, 53 to 55 jurisdictions. I attended, well, let me back up. NASBA holds a quarterly meeting with the executive directors and state board chairs. And so I attended that meeting. That was March the 10th of this year. And at that meeting, NASBA pled with the state board chairs and executive directors for the respective states to respond to the exposure draft. And so that was done at the start of the meeting, and then probably the last 10 minutes of the meeting, NASBA's vice president, one of the vice presidents, Ken Absick, who's been here and presented before this board, again, strongly suggested that each state submit a response. And so I have changed my position on that, and I would like for us to comply with that request and submit a response. Jen has faced similar, I think you said it didn't rise to the level of pressure, but strong encouragement for our board to submit a letter in response to the exposure draft. So as part of this process, during the meeting that I mentioned on March the 10th, I asked NASBA to provide us with some templates, possible letters for us to use to respond. And one thing NASBA said is you can just copy our letter and put it on your state letterhead and respond to a Me Too letter. And I don't think any states are doing that, but a number of states at this point have submitted a response to the exposure draft, and they vary. Connecticut, I've seen their letter, and basically their letter says this is too complicated and we need something more simple. I personally don't know how you make it much more simple because the issue is complex. And so the whatever rules and regulations we come up with is probably going to be complicated. But I asked Jen to prepare a draft for us to discuss today. And I would like for us to submit a response based on NASBA's encouragement that we do. And they feel that'll make an impact with peak. Maybe not our individual letter, but all the letters from the jurisdictions will help. Jen drafted a letter and used a lot of the language from NASBA. And I reviewed the letter and we had made a few tweaks. And then subsequently, I asked Jen to consider adding one more section, which I think you did, Jen. But so Jen has gotten the draft prepared and you have it before you. And there are four major sections. You see those in bold. And I don't think it would be productive. We can do this if you want to, but I don't think it'd be productive if we have 9 or 10 different authors of this letter today. But I think if we talk about concepts and not really work on wordsmithing, but are we in agreement with this in general, at least conceptually? So Jen, having said that, I'll turn it over to you.
Yes, thank you. So I will say comment letters were due to the AICPA on April 30th. They granted us an extension to the end of this week. As I said, this may be an item. I did not guarantee that we would submit a letter, but I said this may be an item that the board would wish to reconsider. and we are not meeting until May 5th. So with that, we have the benefit of having heard more, having received more education. I have received more education. It's still complex, I will say. I have received more education since the February board meeting on the topics that are up for exposure. And we also have the benefit of having seen NASBA's recommendations from a regulatory perspective, recommendations from other states. And when I drafted this letter that is before you, I chose to include the topics that I feel are the most easily digestible for this board to discuss and review and consider today. And these align with concerns that are shared by many other state boards and, as Greg mentioned, NASBA. So the letter is structured to include an introduction. We acknowledge that, as we have discussed before in February, private equity investment in the accounting profession is an emerging trend that offers accounting firms opportunities to modernize, to attract talent, opportunities for growth, and our board is supportive of innovation and adaptability. Well, I don't speak for the board. Board staff, I am supportive of innovation and adaptability for accounting firms in Tennessee, while also ensuring that we remain committed to our mission of protecting the public and ensuring that the public is aware of who they're hiring, the relationships that their attest firm may have with its closely aligned non-attest entity, and the investor structure related to that, whether there's private equity involvement or not. So the topics that are included in this letter: independence in fact and appearance. As we all know, independence in fact and appearance are two critical elements to maintain in the AICPA Code of Professional Conduct. The exposure draft addresses kind of a structural permissibility concept, provides a framework for that in the draft, and it does not much address independence and appearance. Independence and appearance, I think I have the definition in here and I took it out, so I won't be able to quote it exactly, but it's, you have an informed third-party person who has knowledge of the facts and circumstances and can make a decision that independence is maintained in appearance. So there is a concern from the regulatory community that independence and appearance is not addressed within the exposure draft, or at least not enough emphasis is placed on it. There's also, as Greg mentioned, just kind of the general complexity associated with this topic. So complex transactions lead to complex relationships, lots of things to be considered by CPAs who are taking on attest clients. And not only do I believe that it is going to be complex for CPAs to assess, the CPA audit partners who are presumably in these firms who are taking on audit clients, but it will also be, and I think the board has kind of hit on this at the February board meeting, it could be complex for us to regulate. So as allegations come before this board, if they come before the board, independence failures, allegations of clients not being independent of their auditor, it would be complex for us to investigate and adjudicate those cases potentially. The third point in here, I've included a reference to paragraph 59 of the exposure draft, which you have a printed copy of at your seat. And the paragraph 59 states that members, meaning CPAs, are not required to monitor for the existence of these relationships that require application of the conceptual framework. However, members should apply the conceptual framework when they know or have reason to believe a relationship that may create threats to independence exists. And I think the concern there is that there's not an expectation for continuous monitoring when we know that any investor structure we expect to be changing with some frequency as it grows or shifts or changes. So I would hope that there would be a requirement at some level for continuous monitoring for the firm of those relationships. And then finally, transparency and disclosure to the public. I borrowed some language from NASBA's response to the exposure draft, but just noting that it is critical that users of attest reports, clients, lending institutions, the public making investment decisions. There's a wide range of stakeholders that place reliance on attest reports. And I believe it's critical that those users of attest reports understand how their firm is related, how their attest firm is related to the non-attest entity, and how that non-attest entity fits into the investor structure that they are a part of. So the ask would be full transparency regarding the parties involved in an APS arrangement, being critical not only to financial statement users, but also to other stakeholders. Also, other stakeholders with responsibilities for understanding the closeness of the relationship between the auditor and the auditee, such as audit committees. So in conclusion, I added some thoughts that the board had shared in February. Specifically around the board has expressed concerns, the allegations of independence failures would likely require adjudication of the facts and a judgment rendered by civil courts of competent jurisdiction to determine an interpretation of independence requirements for these firms that are closely aligned to non-attest firms with a complex ownership structure. So I guess in summary, the ask for the board today, Greg has mentioned there is an interest in responding. NASBA has asked us to consider responding. I am happy to alter or add or take out anything in this letter. It is a draft. These are so far my thoughts with Greg's review, based on what I have learned and heard in discussion with other boards of accountancy and NASBA. Obviously, this is written from the point of the board, but I don't want to stand in a position of saying that I speak for the board if the board does not agree with what I have drafted. So at that point, I'm happy to answer questions or take suggestions or thoughts on next steps for this.
Jenna, personally, I think your letter is well done, so I have no objections with anything in it. I'm happy for you to send it on our behalf, presuming everyone else is. Procedurally, and maybe I should know this, but there's clearly going to be there will likely be a nexus here with respect to CPA firms who are issuing opinions before the SEC, and therefore are scoped into PCAOB independent standards as well, or SEC/PCAOB independent standards. I presume that the AICPA is coordinating. They aren't always the same, but they closely align. Since the SEC obviously has a vested interest in many of these topics as well, in terms of understanding, where conflicts exist, understanding where disclosures need to be made, et cetera, et cetera. So am I right in saying that the AICPA they're following along with the SEC and monitoring, and then this rulemaking is also considering what the SEC's sort of posture is on these matters?
I'm not sure. I have not heard in our discussions that, I know we've talked about before the PCAOB. I don't think that the PCAOB has started taking a look. Well, not that they've started taking, there haven't been any findings that have come up yet. In terms of SEC independence rules, I am not sure how they align with where Peak is going with this.
Okay.
I was going to ask you or Sam about that, because I agree that the SEC is going to weigh in at some point, I would imagine, if they haven't already, but I didn't know if they had. And I feel like AICPA typically follows what they do, but we're not sure, I guess. I like your letter. I think it makes sense. So
I think historically, Peak has tried to align with SEC comments and requests, but I don't know in this specific instance if that's been done or not either.
I like the letter. I like the alignment that brings into focus some of those key components, independence, appearance, and fact, and then goes into the recognition that I think many initial readers wrestled with, and that's it's complex. How do we determine how it applies? And I also love that it talks about that part on the monitoring. So alignment with NASBR and us stepping into that space to provide some feedback is very appropriate. I'm glad that we did this. So thank you for asking for that extension as well. And likewise, Mr. Chairman.
Others? John?
I'll just say I think the letter's well done, and I know you're suggesting that they help the state boards sort of in writing them in response to their request that all the states maybe, or very many states do it. I'm sure was a good guidance to you, and I'm very confident that NASBA's letter that they wrote, as Greg pointed out, to their resources and having some familiarity with it, that their letter would be very, very good too, and they wouldn't have too many, they wouldn't have held back too many things, most likely. I think at the end of the day, if nothing else, it's a sort of a show of solidarity among the bodies of state boards who are charged with oversight, regulatory oversight. And so I think it's good that, Peak, at the end of the day, here's as many as possible, even though they're probably a lot of in the same vein, but that's okay.
Other comments? I think what Jen and I are most comfortable with is if the board officially approves this letter for submission. So if there are no more comments, I would entertain a motion to approve the letter for submission to Peak.
Make a motion.
Motion's made. Do we have a second?
Second.
Second. Roll call vote, please.
Sam Bennett.
Aye.
Brad Buchanan.
Aye.
Oh,
Let's begin again. Sorry.
Okay.
Sam Bennett,
Aye.
Brad Buchanan,
Aye.
Michael Bryant,
Aye.
Brad Floyd,
Aye.
Greg Gilbert,
Aye.
John Griesbeck,
Aye.
Amelia Hart,
Aye.
Daniel Moore,
Aye.
Rob Vance.
Aye.
Thank you very much. And thank you, Jen. Jen has spent an enormous amount of time on this, and it's well done. And so thank you for your efforts on that, Jen. At this point, I think that's all the old business. Do you have any other old business, Jen? We'll move to the new business section, the agenda. Nothing? Okay. Public comment. Do we have?
Mr.
folks?
Gilbert,
Yes, sir.
before we go to the public comment,
Yes, sir.
would you please allow us a short recess?
Sure. 10 minutes? Something
Yes,
like that?
sir.
Okay. Sounds great.
Thank you.
We will, at this point, resume our meeting. Mr. Lott, do you have any comments? We're in the public comment section of the agenda.
No, sir, I have nothing.
Okay. Do we have public comments?
No, sir, nobody's indicated that.
We have one.
No one in the chat and no one signed up? Okay.
I should clarify for the record, an individual did initially put his name off, but he's withdrawing it.
Okay.
On the list of public comments.
Okay. Jen, I believe we've covered all agenda items. Do you agree?
I agree.
Okay, so how about a motion to adjourn?
I'll make that motion
A
for you.
second. All in favor? We won't do a roll call on that one. Thank you very much. Very productive meeting.